Yes, I have under probation revocation calendar, position number 2, Miss Regine Charles.
Okay, let's do that first. Ms. Charles, my name is Judge Lal. If you can see me on the screen, you good?
Yes.
All right, good. Ms. Charles, first of all, I'd like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you today is Ms. Helen. Good morning, Ms. Helen.
Good morning, Judge.
All right. So, Ms. Charles, we are going to have a probation replication hearing in which the probation officer, Ms. Middleton, is going to testify as to the reasons why they are seeking a revocation of your sentence. And then I will let your attorney speak on your behalf. Understood?
Yes, ma'am.
All right. Ms. Middleton, good morning.
Good morning.
All right, let's proceed. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. All right, we have case 17 CR 027373H, State versus Regine Charles. Could you tell me what's this case about and why we're seeking a revocation?
Your Honor, she appeared before Fulton County State Court on April the 19th, 2018 for the charges of shoplifting and was sentenced to 12 months to probation and to complete a shoplifting course. Your Honor, she has 1 month and 7 days left on probation, but probation is going to recommend that her case be closed and she receives credit for time served.
Any objection, Ms. Helen?
No, Judge.
All right. Ms. Charles, we're going to deem this to be a probation violation. Your time at the jail is going to be considered your time served on this violation, and the case is now closed. Your any probation obligations for this case is over and done with. Understood?
Yes, ma'am.
All right. Thank you.
Thank you, Judge.
Your Honor,
Yes.
under SAP calendar,
Yeah.
the Whitney Craig, Amanda Rouse, and Tara Gray, I believe they are downtown, but I will confirm that in a few minutes.
Okay. Sounds good. If you don't mind, then I'm going to move on to another location. I don't see courtroom 1 or 2 on the Zoom yet, so I'll begin with 7th South. 7th South. Good morning, sir.
Morning, how you doing?
Fine, thank you. Who do we have?
Number 35, Mr. Watson.
35, okay. We have State versus Gregory Watson, case number 22 CR 000824J. Mr. Watson, my name is Judge Lal, and this is an all-purpose criminal calendar in which your case has already been accused and you have a bond on your particular case. I'd like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. Ms. Helen, for this particular case, is a negotiated plea, correct?
That's correct, Your Honor.
All right. So, Mr. Watson, I understand that you plan to enter a plea of guilty or no contest to the charge. So what we're going to do first is hear from the prosecutor, and then after that, I'll hear from your attorney. May I place you under oath for purposes of this hearing?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Segura, good morning, sir.
Good morning.
All right. And do you have a recommendation for this particular case?
The state is recommending 12 months with credit for time served, 12 months.
All right. Ms. Helen, any objection to that particular sentence?
No, Judge. This is a time served deal. We agree with the state's recommendation, and we stipulate to the factual basis, venue, and ID.
Does he have any other holds at the case?
Yes, he does, in another case, Judge.
All right. Mr. Watson, are you under the influence of any kind of medication, drugs, or alcoholic beverages?
No, Your Honor.
Oh, something distracting you?
No, Your Honor.
All right. I'm just going to ask you a few questions. I just need your attention. Are you satisfied with the representation of your attorney?
Yes, Your Honor.
If you decide to take this plea today, you would have to give up your rights to go back to court, to have a trial before a judge or a jury, to challenge the state's case, examine witnesses, confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
Is anyone forcing you to take this plea today?
No, Your Honor.
Are you satisfied? I'm sorry, I already asked you that. Okay, so in that case, how are you pleading today?
Guilty.
Accept your plea of guilty. Your sentence is 12 months. Given credit for the 12 months you've already served, your obligations for this case is essentially over. Thank you, Mr. Watson. Mr. Hazen, good morning, sir.
Thank you, Judge.
Yeah, going to the fifth floor
Good
now.
morning, Your Honor.
All right, so who's your client?
My client's name is Thomas Johnson.
Thomas Johnson.
Yeah, and there's a plea offer on the table, but if I can speak with him briefly in a breakout room, hopefully we can move this.
All right, I don't know. I think he might be brought into courtroom 2, but courtroom 2 is still presently empty. 7 South, yes, Deputy, what was the announcement? 7 South?
Yes. I'm about to go to the fifth floor now. Courtroom 2 should be on shortly.
Okay, thank you.
Uh-huh.
All right, Mr. Hazen, unfortunately, we are all at the mercy of how the jail facilities bring the individuals forward.
I'm here. I'm here.
All right, so as soon as Mr. Thomas Johnson, is that Thomas Johnson?
This is Chance. That's Mr. Ward.
That is.
Okay, so Mr. Hazen, I'm afraid you just have to wait until your client pops up on one of these screens.
Okay, I'll be here.
All right.
Thank you, Your Honor.
Mr. Hazen, you can call extension 22392. Give me about 1 minute. I'm gonna pull them out the tank. 22392. So that's 404-612-2392. You got it?
I got it. I'm going to call right now. Thank you.
All right, give me about 1 minute. Give me 1 minute.
Okay.
All right.
Give him two. Give him 2. Okay. Okay, and I'm so sorry. So what's your last name again?
Ward, W-A-R-D.
Position 34.
Thank you. We have State versus Chance Kyler Ward, case number 22 CR 000-839J. And Mr. Ward, I'd like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. This will be a negotiated plea.
Correct, Your
And
Honor.
Mr. Ward, in order to ascertain that your decision to enter a plea is going to be willingly and voluntarily made, I would need to ask you some questions eventually. So may I place you under oath?
Sure. Yes, ma'am.
Could you raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. May lower your hand. Mr. Segura, yes, sir. What is the offer for Mr. Ward?
The state is recommending 12 months to serve 30 days, credit for time served 15 days, balance probated, a 6-week anger management course, a stay away from the Comfort Inn located at 1500 Market Boulevard, apartment 400, Roswell, Georgia, and no further contact with Reginald Lanion.
All right. Thank you, sir. Ms. Helen?
Yes, Judge, we agree with the state's recommendation. That is our understanding of the offer. We also stipulate to the factual basis, venue, and ID.
Anything else that you're seeking for your client, Ms. Helen, in terms of probation?
Yes, Judge, I would ask for the probation fees to be waived, and that once he completes those 6 anger management courses, could it be suspended or non-reporting, Your Honor?
Any objection from the state with regards to non-reporting?
None.
All right. All right, before I proceed with Mr. Ward, Mr. Findling, your client, the one you put in the chat, is he at the jail facility? In the courtroom facility, I mean courtroom 2?
Yes, Your Honor. Yes, Your Honor. He is a PV case, and I didn't get the petition in time to go over with him.
Okay. What's your client's name again?
It's Mr. Eric Barlow. He's one of the probation cases.
Deputy, is Eric Barlow in courtroom 2?
Yes, he is, Your Honor.
All right. Mr. Findling, after Mr. Hazen has completed his conversation with his client, you may call the jail at 22392.
Got it. Okay. Thank you, Judge.
Thank you. Mhm. All right. Mr. Ward, with regards to the plea offer made by the state, first of all, are you under the influence of any kind of medication, drugs, or alcoholic beverages?
No, ma'am.
Have you understood the proceedings so far as they transpired?
I guess, yeah.
All right, I'm going to ask you a few more questions, and if you have any inquiries about, or if you don't understand anything, you need to let me know. Otherwise, we're just going to forge on. Okay? You understand?
Yes, ma'am.
All right. First of all, your attorney has explained to you the terms of the sentence if you decide to plead guilty, which would require you to take 6 weeks of anger management classes, stay away from the Comfort Inn in Roswell, Georgia, and have no contact with Reginald Lanier. Is that your understanding of the proposed sentence?
Yes, ma'am.
And you also understand that if you decide to plead guilty, that you will be released from the jail within 24 hours, unless you've got any other cases holding you. Have you understood that?
Yes, ma'am.
Are you satisfied with the representation you've received so far from Ms. Helen?
Yes, ma'am.
And is anyone forcing you or inducing you to plead guilty today?
No, ma'am.
If you decide to plead guilty to this case today, to the 1 count of simple battery, you will have to give up your rights to go back to court in the future, to have a trial before a judge or a jury, to have the assistance of counsel to challenge the state's evidence, present your own defenses, confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah, guilty.
All right. I understand that you want to plead guilty, but are you prepared to give up these constitutional rights?
Yeah, for the guilty.
How do you plead to the 1 count of simple battery?
The guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. Your time at the jail is concluded and you will be released within 24 hours. Once you are released, you will have to report to your probation officer within 48 hours. Today is Thursday. You have to repeat to your probation officer no later than Tuesday morning. Do you understand?
Yes, ma'am.
Once you'll be placed on probation, while you're on probation, you will enroll and complete 6 weeks of anger management classes at a qualified provider. At all times that you're on probation, which will be about 11 months, you will stay away from the Comfort Inn at 1500 Market Boulevard. That means staying 200 yards away from that location, the entire location. Do you understand?
Yes, ma'am.
That's in Roswell, Georgia. And you shall stay 200 yards away from Reginald Lanier, not have any communication with him, not see him in person, and not even discuss him on social media. If you have any contact with Mr. Lanier while you're on probation, you run the risk of having your probation revoked. Understood, Mr. Ward?
Yes, ma'am.
I will suspend your probation fees for the first 4 months, which will be March, April, May, June, and I'll include July. So from now until the end of July, you don't have to pay probation fees, but you must report to probation. If you complete your anger management classes by the end of July, your probation will be non-reporting. That means that you don't have to pay and you don't have to report, but you're still on probation until the end of 11 months. Understood?
Okay.
That concludes this case. Thank you.
Thank you, Judge.
All right, we have some folks in courtroom 2. Good morning, folks. My name is Judge Law, and this is going to be the Fulton State all-purpose calendar. This is a calendar of open, active misdemeanor cases that have already been formally accused, and bonds have already been provided for all your cases. Today, we are going to be considering certain things in your cases. If you and your attorney have discussed a possible plea offer from the prosecution, then we may have a plea hearing in which I would have to determine whether you're going to be entering a willing, voluntary, and knowing plea of guilty or no contest to the charges. in exchange for a recommended sentence. Otherwise, if you plan to enter a plea of not guilty, I will do what they call arraign the case. In other words, I will inform you of the charges, what are the possible penalties, and accept your plea of not guilty so that your case may be scheduled for a trial in the future. Other matters I may possibly address is bond modification or anything else that you'd like to bring up before me. During the course of this entire proceeding, which is not only being recorded, but also live streamed, please remember your constitutional rights. The first one is the right to remain silent. Anything you say about the facts of your case during the course of this entire recorded proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one of our attorneys from the Public Defender's Office or Conflict Defender's Office will be representing you. All right, officer, I'm ready for the first case in courtroom 2.
We're gonna go to Mr. Jason Davis. He's position number 8, Jason Davis.
Mr. Davis's case is 20 COB 000356, in which he's been accused of reckless conduct with an alleged date of August 18, 2020. Mr. Davis, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finley. Mr. Finley, we are going to arraign the case and consider bond. Is that correct?
That's correct, Your Honor.
All right. Mr. And do you want me to read the accusation or citation in this case?
No, Judge. Thank you.
All right. Mr. Davis, you've been accused of reckless conduct in this particular case. It is a misdemeanor offense, and upon your entry of a not guilty plea, your case will be scheduled for trial. At the time of the trial, the prosecutor, has the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be found guilty of this offense and serve a sentence of up to a year in prison and or be imposed a fine of up to $1,000. Given this information, how do you plead, Mr. Davis?
I want to plead guilty.
Repeat that, please.
I want to plead guilty, but I think for the 6 months, 12 months and do 6 right now.
May I have a breakout room?
All right, Mr.
Davis,
Davis, you can please go back to your seat on the gallery, and Mr. Finley, you will have an opportunity to call him and speak to him. Officer, may I have my next case?
We can go to position number 9, Mr. Denton, Brandon Denton.
And I have, just so you know, Your Honor, I have number 1 through 18.
Yeah, got that. Thank you.
All right, so I'll go to 19. You want to do this one?
Yes,
Mr.
let's
Finley?
do this gentleman who's up here right now. What's his name again, please?
Position number 9, Your Honor, Brandon Denton.
All right, Mr. Finley, please appear.
Sorry, Judge?
Yeah, is this your client? Brandon Denton?
Yes, Your
Position
Honor.
9. All right. Mr. Brandon Denton, case number 20 COB 000343 is accused of criminal trespass. And Mr. Denton, you've been advised of your right to remain silent, and your attorney is Zach Finley. Mr. Denton's case is going to be a negotiated plea. For purposes of the plea, Mr. Denton, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Mr. Denton, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Thank you. Miss Goodry, good morning.
Good morning, Your Honor.
And what is the offer for this particular case?
The offer is 12 months, 120 days, 60 days credit for time served. The balance is suspended. A stay away from 343 Joseph E. Lowry Boulevard, Southwest Atlanta. That is the Circle K gas station. And if defense stipulates to the factual basis, venue, and ID, we have nothing further.
All right. So he would have to stay away from the Circle K gas station for at least the next 8 months. Is that correct?
That's correct.
All right. Mr. Finley?
Yes, Your Honor. We do agree to the state's recommendation and additionally stipulate to the venue, factual basis, and ID.
Thank you, sir. Mr. Denton, first of all, have you taken any medication, drugs, or alcoholic beverages recently?
Yeah.
Have you understood the proceedings so far?
Yes, ma'am.
All right, you need to speak a little louder so I can hear you, okay?
Yes, ma'am.
Thank you.
Okay.
Mr. Denton, there's been a recommendation that you be given full credit for the time you've been at the jail, that you be released within 24 hours, and that you would need to stay away from the Circle K gas station at Joseph E. Lowry for the next 8 months. Is that a doable thing?
Yes, ma'am.
All right, staying away from Circle K means staying 200 yards away. You cannot be on its parking lot, on its sidewalk. You cannot be on its anywhere near its property, and you definitely cannot be in the store. So is that your understanding?
Yes, ma'am.
Are you satisfied with the representation of your attorney?
Yes, ma'am.
And if you decide to take this plea today, you would have to give up your rights to go back to court in the future, to challenge the case in a court of law before a judge or a jury, to have the assistance of counsel to present your defenses, challenge the state's evidence, confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the 1 count of criminal trespass?
Yes.
Your sentence is time served. You are going to be released within 24 hours unless you have any other cases holding you at the jail. Once you're released, you need to stay away from 343 Joseph E. Lowry Boulevard, which is the Circle K gas station that we just discussed. Thank you.
Okay.
And should I call now to speak with?
Well,
Mr.
let me see who's going to be the next person.
Okay.
Deputy, who would you like to call?
Position number 19, Jesse
All right.
LeMay.
Okay, Mr. Finley, go ahead and call and speak to your client.
Okay.
Was it Mr. Davis? Yeah.
I'm gonna
Still
Mr.
in use, Your Honor. The phone is still in use.
Oh,
Okay.
okay. All right, Miss Helen, we have your client, position number 19, Jesse Daniel Richard LeMay, case number 21 CR 004292E, in which Mr. LeMay has been accused of criminal trespass and loitering or prowling. With regards to position 19, this is going to be a negotiated plea. Mr. LeMay, you've been advised of your right to remain silent, and your attorney, it will be Miss Helen.
Yes, ma'am.
For purposes of this plea, may I place you under oath, sir?
Yes, ma'am.
Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am. We've entire truth.
Thank you.
Yes, ma'am.
All right, Miss Duncan, good morning.
Good morning, Your Honor. This is a negotiated plea. As you know, the state is offering global recommendation of 12 months to serve, 24 days, credit for time served, 12 days, balance probated, MHET, and a stay away. And we are willing to null across the second count of loitering and prowling.
All right. And from where does he need to stay away?
One moment, Your Honor. The address that we have is, the incident location is 500 Richard Allen Boulevard at the Big Bethel Village Senior Living Facility.
Big Bethel Senior Living Facility.
Yes.
All right, thank you. Anything else, Ms. Duncan?
No, Your Honor, that's it.
Thank you. Ms. Helen?
Judge, this is a negotiated plea. We do agree with the state's recommendation, and we stipulate to the factual basis, venue, and ID.
Mr. LeMay, are you under the influence of any kind of medication, drugs, or alcoholic beverages that may impair your ability to think clearly?
No, ma'am, but I am on medication here.
All right. Well, I'm not sure if you've taken any of the medication. I can't hear you.
Oh, no, just for medical. They just for this.
Okay. And have you understood everything that's been happening so far?
Yes, ma'am.
And have you understood the explanations that your attorney has given you?
Yes, ma'am.
And are you satisfied with her representation?
Yes, ma'am.
If you decide to take this plea to one count of criminal trespass, you would have to give up your constitutional right to go back to court in the future, to have a trial before a judge or a jury, have the assistance of counsel to examine witnesses, confront your accuser, challenge the state's evidence and present your own defenses, as well as have the state try to prove the charge against you beyond a reasonable doubt.
Okay.
Are you prepared to give up these rights?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence, Mr. LeMay, is going to be 12 months to serve 24 days. Credit for time served 12 days. So your time at the jail is concluded. You'll be released, but you must report to probation by Tuesday morning
Where at?
at 132 Mitchell Street. That will be in your paperwork when you're discharged from the jail
Okay, will I be discharged?
within 24 hours. Once you're on probation, you must report every month.
Mhm.
I will waive your probation fees. And while you're on probation, you will need to take an evaluation and possible treatment based on what your probation officer tells you. Do you understand?
I understand.
And you must complete that evaluation and any treatment. You must complete the evaluation within 3 months of being released.
Okay.
You can't, I'm not going to have you just sitting on this until the last minute. Do you understand?
I understand.
Do you have any family or relatives at the Big Bethel Senior Living Facility?
No, ma'am.
All right. So there is no reason for you to return to that property, correct?
No reason, no, ma'am.
If you return to that property, you will be arrested and brought back here, and we get to do this all over again.
Yes, ma'am.
So stay away from 500 Richard Allen Drive, was it? Road? Boulevard at the Big Bethel Senior Living Facility. As I said, if you return there, we get to bring you back here on the red carpet. Good luck.
Thank you.
You'll sit back over there.
Thank you, Judge.
Position number 13, Mr. Frazier.
Hey, Matthews,
Yeah.
I thought Finley was gonna call extension 22392. I sent you a message in the chat, Finley.
Okay, I can call. Mr. Frazier's is mine. I thought the phone was still being used. I apologize.
No, that's no problem. Go ahead and I'm sorry, Mr. Frazier, just 1 second. Deputy, is position 16 available right now? I see Mr. Hazen available. That would be Thomas Johnson.
Yes, he's available, Your Honor.
All right. Mr. Frazier, we will be with you very shortly because Mr. Finling is speaking to another client. Mr. Hazen, let us proceed with your client, and that's position 16. State versus Thomas Johnson, case number 17 CR 024647Y, in which he's been accused of theft by receiving stolen property from an October 2017 incident. Mr. Hazen, Mr. Barry Hazen. Oh dear. Mr. Barry Hazen.
Way around it. I just want to see if they can cut some time down if they could, but I have to do this in time.
Barry Hazen, attorney Barry Hazen.
You know, programs, say the programs and all that. Zoom with that.
Okay. Attorney Barry Hazen. Does the host have the ability to call Mr. Hazen directly and let him know that his case is, there he is. Okay, Mr. Hazen. All right.
Sorry
sir.
about that. I turned the volume off for just a second.
No problem. I thought you were distracted by that awesome view in the background. Okay, there we go. All right. Mr. Hazen, your client's seated there and he has been advised of his right to remain silent, and he's represented by attorney Barry Hazen. He's also been advised of his case number and the charge against him. Mr. Hazen, you've had a consult with your client.
I have, Your
How
Honor.
are we proceeding with your case?
He has indicated that he wants to accept the state's offer of negotiated plea. He's entering a plea of guilty, and I understand that the offer is time served.
Yes, that's what I understand. Ms. Duncan, is that correct?
Yes, Your Honor, that is correct. The state is recommending time served for the guilty plea.
All right. Does he have any other holds at the jail?
Not that I'm aware of.
All right. So Mr. Hazen, unless he's any other holds, he should be released within 24 hours. Is that your client's understanding?
That's what we discussed, yes.
All right. I wish I could make it faster, but that's how, that's the ballpark I give everyone in terms of how long it takes to process out of the jail.
Yeah, I do that, explain that to my clients, that sometimes it takes a while to get from the cell door to the front door. I know, and they're aware.
Okay, good. Mr. Hazen, does your client stipulate to the factual basis, venue, and ID?
We do, Your Honor.
All right, thank you. If you could unmute courtroom 2, please. Mr. Johnson, could you raise your right hand, please? Do you solemnly swear the testimony you provide will be the truth to the best of your knowledge?
Yes.
And Mr. Johnson, you may lower your hand. Have you understood the proceedings so far?
Yes.
And you're not under the influence of any kind of medication or alcohol beverages, are you?
No.
Are you satisfied with the explanation of your attorney?
Yes.
If you decide to take this plea today, you would have to waive your constitutional right to go back to court, to have a trial before a judge or a jury, confront your accuser, examine witnesses, challenge the state's case, present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Do you understand that you'll be waiving this right to be proceed?
Yes.
And is anyone forcing you to take this plea today?
Oh.
How do you plead to the 1 count of theft by receiving stolen property?
Guilty.
Your sentence is time served. You should be released within 24 hours. Thank you.
Thank you.
Yeah.
All right, Mr. Hazen, do you have another case?
No, that's it.
All right,
Thank
you
you,
have
Your
a
Honor.
great day. Thank you.
Thank you, you too. Be safe.
Be safe too. All right, next case, please.
We have position 21, Mr. Corey Mays.
Thank you. April, this is for Alonzo Kendrick. Oh, okay. Thank you. We have Mr. Corey Demetrius. May I have a seat, sir? Mr. Corey Demetrius Mays, case number 22 CR 0000855G. Mr. Mays, with regards to this case, I understand that you will be considering entering a guilty plea to the charges or charge.
Yes, ma'am.
All right. And that record, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. If you could please raise your right hand, sir. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. You may lower your hand. Ms. Duncan, what is the recommended sentence for this case?
Yes, the state is recommending for the criminal trespass, 12 months to serve, 28 days, credit for time served, 14 days with the balance suspended, and no further contact with Crystal Torres, and stay away from the incident location at the point at West Side. And for the giving false name and address, we're recommending 12 months to serve, 28 days, credit for time served, 14 days with the balance probated, and 40 hours of community service.
All right. Ms. Helen?
Yes, Judge, this is a negotiated plea. That is our understanding of the recommendation. We are just asking that once he completes the community service, it go non-reporting. And we do stipulate to the factual basis, venue, and ID.
Any objection to non-reporting?
There's no objection.
Mr. Mays, are you under the influence of any kind of medication, drugs, or alcoholic beverages?
No, Your Honor.
And have you understood the proceedings so far?
Yes, I have.
Are you satisfied with your attorney?
Yes, I am.
And has it been explained to you that if you decide to enter this plea, you would have to give up certain rights?
Yes.
Namely, those rights will be the right to a trial before a judge or a jury, to have the assistance of counsel to confront your accuser, challenge the state's case, present any defenses you may have, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am, Your Honor.
Is anyone forcing you to take a plea today?
Not at all.
How do you plead? To 1 count of criminal trespass and 1 count of giving false information to an officer.
I plead guilty.
Your sentence is for the criminal trespass is 12 months to serve 28 days, credit for time served, 14 days. Your time at the jail for this charge is concluded, and you have to stay away from Crystal Torres. In other words, you cannot be within 200 yards of her. You cannot communicate with her in person through any kind of electronic device or through social media. And you need to stay away from this Sail Point location at West Side. Are you familiar with that location?
Yes, I am.
All right, you have to stay 200 yards away from that location. And if you return, they will have you arrested for trespass. You understand, sir?
Yes, Your Honor.
For the false information charge, your sentence is 12 months to serve 28 days, credit for time served 14 days. Once you are released from the jail, you'll be placed on probation. You must report to probation by next Tuesday morning at 132 Mitchell Street. While you're on probation, you must complete 40 hours of voluntary community service. Understood?
Yes.
I will waive your probation fees for March, April, and May for you to complete the 40 hours of voluntary community service. If you're done with everything by the end of May, your probation will be non-reporting, and you won't have to pay probation fees from June 1st onwards. Understood?
Yes.
If you take longer than that, then you'll start, when you report to probation, you need to start paying fees from June 1st onwards. Good luck.
All right, thank you.
Thank you, Judge.
Thank you, Judge.
Your Honor, can we go to the probation case, Mr. Barlow?
I believe position 1 is Attorney Findling.
I'm back now.
Oh,
We have Eric Sharon Barlow for a probation revocation matter in case 18 CR 007420E. Mr. Barlow, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finley. Officer Middleton has already been sworn, and she's going to attest to the reasons why they're seeking a revocation of your sentence. Ms. Finley? Excuse me, Ms. Middleton, excuse me. I'm sorry, could you unmute Ms. Middleton, please?
Appeared before Fulton County State Court on February 19, 2019 for the charges of failure to maintain lane and DUI less safe. He was sentenced to 12 months to probation, pay all fines and surcharges, to submit to a drug and alcohol evaluation, complete 240 hours of community service, complete a victim impact panel class, and complete a risk reduction DUI school course, and to submit to random or weekly drug screens. He has not reported since the last time he reported was April 22nd, 2019. There's a month and 26 days left on the case, and we're going to recommend that his remaining balance be revoked and he does not return to probation.
Yes, Your Honor. I just did speak with Mr. Barlow, and we went over where he has fell short. He did take ownership of some of what he has missed. He does still need to do the community service. I understand his time is dwindling away fast. He did complete the MAD panel, he says, and he also says that he did complete the risk reduction DUI school judge. We are asking for the balance not to be revoked, and that he could resume on probation, Judge.
Do I have a pre-trial officer here? Ms. Harrison?
Good morning, Judge.
Good morning. Mr. Eric Barlow is on a probation revocation calendar. Do you have a GCIC on Mr. Barlow?
I don't have that calendar, but if you give me a booking number, I'll have it in a moment.
1903737. I need to know how many DUIs he's had on his record.
One moment, Your Honor.
Ms. Middleton, are you familiar with this GCIC?
I'm sorry, Your Honor.
Are you familiar with this?
Your Honor, there's a
record?
2009 and a 2017.
Okay, 2009 was a DUI conviction and 2017 is the case we're dealing with over here.
Yes.
Anything since then? Anything
No.
in, after 20, anything in 2019 or 2020 or 2021?
He has a one this month, but it's a probation violation. So no, the last one was 2017.
Okay, thank you. Mr. Findling, I will give your client the full credit of 18 days, not 36 days. He's getting the raw credit to the time left on his probation. Ms. Middleton, if you can do the math for me, if I'm giving him 18 days, actual 18 days credit, how much time does he have left on probation?
Give me 1 second. Let me see. He has a month and 26 days.
I have 1 month and 8 days left. Is that? Okay. So, Mr. Findling and Mr. Barlow, he can serve 30 more days at the jail to complete his sentence for this in lieu of doing 240 hours of voluntary community service. Otherwise, I can give him credit for the 18 days. He will be reporting to probation once a week, and he would need to do 40 hours of voluntary community service for the remainder time of 1 month and 8 days. So 40 hours a week for voluntary community service for 1 month and 8 days. And that's the exact time that he's got left once he's completed the 18 days. What would he like to do?
Mr. Barlow?
So I'm kind of confused on.
There's no confusion, sir. You have not completed with your terms of your DUI sentence, and you have no proof that you have completed 240 hours of voluntary community service. You can spend an additional actual 30 days at the Fulton County Jail, and then your case is closed. Or You can be released and report to probation every week and show proof that you have completed 40 hours of voluntary community service every week.
Understand.
It'll be doing voluntary work on a full-time basis.
Understand. I'll take that offer, please.
Which one? Jail time or
The
community
public-
service?
Community service, Your Honor.
All right. So we're going to give him credit of 18 days on his remainder time. He'll be released within 24 hours. Today is Thursday, so I'm assuming his first report date will be Tuesday. Try to do as many hours of voluntary community service as you can, and then you'll be reporting every week,
Yes, Your
which
Honor.
prove that you have completed a minimum of 40 hours of voluntary community service. You
Yes,
will
Your
need a supervisor's letter and proof that you've completed 40 hours.
Yes, Your Honor.
And this will continue until the 1 month and 8 days is concluded.
Yes, Your Honor, understand.
All right. And Ms. Middleton, if he doesn't show proof of completing minimum of 40 hours each week, which is a full-time job for anyone, you can go ahead and suspend his probation, issue an immediate warrant, and we can do this all over again.
Yes, Your Honor.
All right. Do you have any questions, Mr. Barlow?
No, ma'am, thank you.
All right. And oh, by the way, no drugs and no alcohol screens. You will be subject to screening by probation.
Yes,
So
ma'am.
for the remainder of the 1 month and 8 days, no booze and no drugs.
Yes, ma'am.
All right. Thank you. Mr. Findling, we good?
Yes, Your Honor. Thank you.
All right.
That concludes. May I be excused, Your Honor?
Yes, Ms. Milton, if you'd like, you can send the paperwork to April Champion.
Okay, thank you.
Thank you.
All right, got number 13, Mr. Frazier again.
Daryl Frazier is represented by Mr. Findling, and he is, Mr. Frazier, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and you're going to be represented by Mr. Zachary Findling. Oh, is it Zach or Zachary? I'm sorry.
Zach is fine, Judge.
Zach.
Thank you.
I was about to call you Zachariah, so.
Not quite.
Okay, your client is Daryl Frazier, case number 22 CR 000-831E, accused of carrying a concealed weapon, misdemeanor possession of marijuana, and fare evasion. This incident occurred on February 17, 2022. And this is going to be a negotiated plea, Mr. Finley? No, he's going to arraign him. Okay, he's going to be arraigned. Okay.
Correct, Judge.
So, Mr. Frazier, I understand that you would like to enter a not guilty plea and have your bond reconsidered for purposes of this arraignment. Do you want me to read the accusations, Mr. Findling, or waive them?
I waive them, Your Honor.
All right. Mr. Frazier, these are the 3 misdemeanor offenses that I've just listed, and they have been formally accused against you. You have a right to enter a plea of not guilty, and upon such entry, your case will be scheduled for trial. At the time of the trial, the prosecutor would have the complete burden to prove the charges against you beyond a reasonable doubt. If at the time of trial, the state succeeds and overcomes your legal presumption of innocence, you could be convicted of 1 or more of these charges. With regards to these charges, the fare evasion, you could be convicted and sentenced to up to 6 months in jail and or up to $1,000 fine. With the other 2 charges, you could be convicted to up to 1 year in prison and or up to $1,000 fine each. Given this information, how do you plead?
I plead not guilty, ma'am.
All right, thank you. Your attorney is going to argue for a bond modification. Your bond was set at your initial appearance, and I believe you have a surety bond on the weapons charge. You may proceed, Mr. Findlay.
Yes, Your Honor. I have that it is a $3,000 total bond, Judge, $500 for the fare evasion, $500 for the marijuana charge, and then $2,000 for the weapon, for the concealed weapon, Your Honor. Mr. Frazier is 29 years old. He has his own little business moving furniture. He has two young girls, both of whom he cares for financially, as well as he's very much active in their lives. That's the center of his world are his two daughters, Judge. We do want to get him home to his daughters, and he has a strong community ties to the Atlanta area and Fulton County. As we know, bond is not meant to be punitive, but rather to ensure his return to court. And I really stressed the importance to Mr. Frazier of his return to court. And that's why we are asking for a signature bond in this case, but if not inclined, then a $1,000 surety bond, Judge.
All right, yes, I'm sorry I misspoke about the bond. That's normally my standard bond for these kind of cases. So let's see what Ms. Goodry thinks. Ms. Goodry, what do you think?
Your Honor, I ask that you maintain that bond, given that this case involves a firearm that was loaded with 8 rounds in the magazine and one in the chamber. He also has an extensive risk of reoffending given his open cases. He has an open case out of DeKalb for simple assault, family violence, open case out of College Park, simple battery, 3 counts of terroristic threats out of Henry County, all open. He was indicted on those charges on September 1st of 2021. And I also found 3 cases out of Indiana with no disposition, and they seem to still be open as well. So given his criminal history and the fact that this involves a gun, we ask that you maintain the bond.
Do you have the, if you don't mind, I'm going to ask Ms. Harrison. Ms. Harrison, with regards to Mr. Frazier, position 13, do you have the incident dates for the terroristic threat and the DeKalb County case, the simple battery?
One moment. I'm showing his last arrest was March of 2021 in Henry County for terroristic threats.
Okay.
That's what I have as well.
And is there a open DeKalb case?
There's no disposition listed. It just says that it was indicted on September of 2021.
So it's an open felony case.
Correct.
And does he have any felony convictions on his record?
Doesn't appear to be in Georgia, but he has history in Florida, Alabama, and Indiana.
Are they felony convictions?
One moment. He has a felony theft in Florida. That was in 2013. It does indicate a felony. And he has misdemeanor domestic battery convictions in Indiana. That was 2014 misdemeanor.
Okay, that explains it. On the fair evasion, I'm going to amend that to a signature bond through the jail. The marijuana is going to be amended to a signature bond through the jail. But carrying a concealed weapon, given Mr. Frazier's criminal record history, given the fact that he has a felony conviction, at least from what his GCIC indicates, and a domestic violence conviction, as well as a recent case from March 2021 for terroristic threats and a simple battery case out of DeKalb, it just doesn't sound right with the open history and the open cases involving elements of violence, and then an allegation of carrying an allegedly a loaded firearm in a public facility like our Armada station. So I totally understand the bond now as issued by Judge Williams. and the surety bond on the weapons charge and its conditions remain as is. So Mr. Findling, at least on the fair evasion, I agree. I'm going to put those as signature bonds through the jail, but the weapons charge in light of the client's history just doesn't justify a warrant of modification.
Understood, Judge. Thank you.
All right.
Just a quick question on the
Yes, sir.
on the bond modification. So I'll just leave that as a 5, like leave the number value the same and just SOB.
Yes.
Okay.
Yes, yes. And if it hasn't been indicated, I do believe Judge Williams also indicated stay away from all model property. Yeah, stay away from all model property, no illegal drugs, no alcoholic beverages, and no weapons and no firearms. So.
Okay, got it. Thank you, Judge.
And if the state is persuaded that Mr. Frazier has a felony conviction on his record that's not subject to first offender treatment, then y'all might want to consider alternative plans.
Okay.
Thank you. This concludes the case. Yes, Mr. Frazier.
So I only have one question. So how much will my bond be now for the firearm now?
It is a $2,000 surety bond.
Okay, so I could bond out with a bondsman?
You may bond out with the bondsman, but you're not allowed to possess any weapons, no firearms. You cannot have a firearm on your person, in your home, anywhere near you, or in any vehicle you occupy. You cannot return to any MARTA property. You have to stay 200 yards away from all buses and train facilities, and you cannot consume any illegal drugs and no alcoholic beverages.
Yes, ma'am. Thank you so much.
All right. Thank you.
Yes, we got number 17, number 15, Mr. Hannibal.
This is State versus Darren Hannibal. Are you Mr. Hannibal? Yes? Sir, are you Mr. Hannibal?
Yes, Your Honor.
Thank you. This is case 22 CR 000842F. Mr. Hannibal, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Findling. And Mr. Findling, with regards to Mr. Hannibal, this is going to be also an arraignment and a bond modification hearing. Is that correct?
That's correct, Judge.
All right. Mr. Hannibal's particular case is incident date appears to be February 17, 2022, allegedly in Fulton County, Georgia. And he has been charged with a litany of misdemeanor traffic-related offenses, which include failure to signal a lane change, failure to obey a traffic control device, fleeing or attempting to elude a police officer, reckless driving, and attempting to misrepresent a tag, and driving with an expired or no license plate and decal. These are misdemeanor offenses to which Mr. Hannibal is presumed innocent until the case goes to trial, and the state has the complete burden to overcome his presumption of innocence and prove the charges beyond a reasonable doubt. If the state succeeds in proving these charges beyond a reasonable doubt, then Mr. Hannibal could be convicted of one or more of these offenses and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Mr. Findling, shall I read the accusations, or would you like to waive a reading of them?
We waive those, Your Honor.
All right. Mr. Hannibal, given the information you've been provided so far, how do you plead?
Not guilty, Your Honor.
All right. This case has been arraigned and will be further noticed for trial. Your attorney will be seeking a bond modification. Please proceed, Mr. Findling.
Yes, Judge. I show that altogether his current bond is $30,700 surety, Your Honor. Mr. Hannibal is 30 years old. He's found a recent niche of songwriting, and that's really started catching on shortly before he got arrested, Judge. Finances, though, are not, they're not thriving yet in his life. This is a $30,000 surety bond, which he cannot come close to being able to afford.
I'm sorry to interrupt, but I'm looking at the bond order. Unless I'm mistaken, it says 3030, so it's 3,030. Did you see an extra zero?
Your Honor, if I may, he is
Yes.
currently being held on a $30,730 bond. And under this booking, he was booked under 14 charges, which include misdemeanors and open felony cases at this time.
I see.
Oh, I got it. I'm
For the
sorry.
misdemeanors, I have a calculation of the total bond being 3230 surety for the 6 misdemeanor charges.
I apologize. Yeah, I was looking at the
No.
top right. I
The
apologize.
total amount, yes, the total amount is 30,730. He's got, yes, he's got a couple of cases in Superior Court. And unfortunately,
goodness.
also a couple of fugitive holds. So,
Okay. So
yes,
I go, understood. So yes, Your Honor, finances are not thriving in his life. So he's unable to make that bond at this moment. That's why on these misdemeanor charges that we're addressing, we're asking for a signature bond, or if not, a surety bond not exceeding $1,000, Judge.
all right, thank you. Ms. Duncan?
Your Honor, these incidences took place on February 17th. The bonds are currently set at $265 for the failure to signal lane change, $265 for the failure to obey signs or traffic control device. Traffic devices, $1,000 for fleeing or attempting to elude a police officer, $1,000 surety for the reckless driving, $200 for the attempting to misrepresent tag. No, $500 for the attempting to misrepresent tag, and $200 for the expired or no driver's license at this time. And we would ask that that bond remain set. Given the facts and circumstances surrounding this case, we're concerned that this particular defendant has a strong flight risk, given that he does have open fugitive for justice cases. He's currently wanted out of 3 different jurisdictions for failure to appear. And in this case in particular, the manner in which the driving took place was very dangerous to the defendant himself and pedestrians and the officers involved. There was a bolo given about a vehicle being driven by a suspected multiple state felon. Given over the radios, police came in contact with that vehicle. And upon making contact with that vehicle, they activated their lights and attempted to get the vehicle to stop. The driver of the vehicle did not stop. The driver actually, which is the defendant, accelerated, driving a gray Infiniti, crossed multiple lanes, made a U-turn over a bore, accelerated speed across multiple streets. Several police cars became involved to give chase, and eventually, due to the dangers involved in continuing to chase the vehicles, officers suspended the chase but put out a description for the vehicle to Georgia State Patrol, and eventually Georgia State Patrol were able to apprehend the defendant driving this vehicle at 3249 Buford Highway while he was on his way there. So given the fact that this defendant was driving at such a dangerous nature and a high speed and causing this concern to police officers and other drivers in the road, we request that the bond remain as stated.
Okay. Mr. Finley, anything else?
Nothing further, Judge.
All right. Well, I'm glad he had Judge Williams because I would have imposed a cash bond. So that would have been one issue. The other issue is he's got a plea offer. Have you all considered that?
Yes, we did, Judge.
Okay.
Yes, we did. We did discuss this.
I'm with the 3 fugitive holds, the open felony case, multiple felony charges, including firearm, and the nature of this particular, how these misdemeanor charges arose. Mr. Hannibal doesn't qualify for any bond reductions. As I said, that's not the bond I would have imposed. So at the present time, the request for a bond modification is denied. This case has been arraigned. It's further notice for trial unless you want me to put on another SAP calendar to reconsider this plea.
If we could, Judge.
All right. I'm going to reset it for March 10th. Or do you want to consider the plea today?
No, Your Honor.
No, okay. And we will leave it as it is. We'll reset for March 10th for a possible plea. I'm going to indicate that no bond modification is authorized in this case. Thank you.
Thank you, Your Honor.
All right, next we have number 17, Mr. Kendrick.
Mr. Alonzo Kendrick is accused of theft by shoplifting in case 20 CER 001310B. Incident date is September 18, 2019. All right, Mr. Kendrick, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your attorney is Mr. Zach Finling. We will arraign this case, so I understand that you'll be entering a plea of not guilty. Mr. Finling, do you waive a reading of the accusation?
I do, Judge.
All right. And as I understand it, that the state has made an offer for 40 hours community service, theft class, and to stay away from the victim's location. Is that correct?
Yes, that's the state's recommendation.
Yeah, but in exchange for a guilty plea. So is that what the holdup is, the guilty plea?
Rest, Your Honor.
I was informed of bond hearing.
No, I'm just wondering in terms of a possible resolution.
Yes, Your Honor. After speaking with Mr. Kendrick, he was pretty adamant that he did not want to take a plea and plead guilty to this charge.
All right, no problem. Mr. Kendrick, you've been accused of a misdemeanor offense of theft by shoplifting from 2019. You have a right to a trial by a judge or a jury with regards to this case. Upon your entry of a not guilty plea, the case will be scheduled for trial, during which time the state has the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails and carries its burden of proof, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead? I'm sorry, I can't hear you, Mr. Kendrick.
Not guilty.
All right, sir. Your case has been arraigned and it's going to be further notice for trial. Mr. Finley, what is the reason for bond modification?
Yes, Judge. Mr. Kendrick is here before us today for an FTA. An FTA where he adamantly states he did not receive notice. And if he did receive notice, he definitely would have been at court. He was very upset because he is someone that respects the legal process in that way, and he just was not aware of his court date. Further, Judge, this original theft by shopping incident is regarding about $50 worth of goods from a Walmart. It is currently a $1,000 good bond right now, Judge, and we are asking for a reduction to a signature bond.
All right. Ms. Harrison, since September of 2019, have there been any subsequent arrests?
He has an open case, Your Honor. It's for 3 counts of aggravated assault. That case number is 22 CP 206932.
206932?
Yes.
Ms. Duncan? Thank you,
Yes.
Ms. Harrison.
Yes, Your Honor. In addition to what Ms. Harrison stated, this defendant is also wanted out of Jonesboro. The state will request that this bond remain as set. Nothing has changed about these circumstances. It took place at 6149 Old National, which was the Walmart. And at that time, the defendant was apprehended with another person when seen on video taking property without paying for it. And they were escorted to the East Point jail. This defendant has 16 total cycles with a theft by shoplifting conviction in 2016. There was a probation violation in 2020. And there have also been several other arrests for theft by shoplifting, including theft by shoplifting out of East Point in 2016, theft by receiving stolen property out of Clayton County in 2018, where he was given 5 years of probation. There was this failure to appear, which occurred on the 23rd of February. And as I stated before, this defendant is wanted. And given the status that nothing has really changed about these circumstances, we would just request that the bond remained as set.
I don't think he was arrested on this particular charge of theft by shoplifting in terms of like, was the case bound over and did he make bond in East Point?
In this case, the facts indicated that he was transported and given a citation, and I believe it was bound over to East Point, to East Point, and the bond was given at $1,000 surety.
Okay. The bond's going to be set at $3,000. It's going to be a signature bond through the jail, provided that Mr. Kendrick provides a valid mailing address. Right now, we have the Flint River Road location in Jonesboro. I don't know if that's a good address.
That's the correct address, Judge.
Yes, Mr. Kendrick, is that a good address?
Yes, ma'am. Can I say something, please?
If you want to say about the facts of your case, you're going to jeopardize your defenses and make it.
It's not the facts of my case. I just wanted to make sure you can at least see if somebody can make sure that they get the right address down, because I wasn't aware about this court date and I paid bond for it the first time, and I just don't want to. We have to go through all this again,
You will go through this all over again if your mailing address is not a good address, number one. And number two, if you don't check your mail regularly, and you are responsible for making sure that where your mail arrives, that is a good receptacle to receive your mail. So yes, you will go through this all over again if we have a good address and we send it out first-class mail, and for some reason or another, you don't get it.
Yes, ma'am.
All right? So right now, you need to stay away from all Walmart stores, not just one, not just two, but all 1 million of them.
Yes,
and your bond is $3,000 signature bond through the jail. Once you resolve your other case, if you get a bond, and if you get arrested again, your next bond is going to be $3,000 surety.
Okay.
Do you and I understand each other?
Yes, ma'am.
All right. Thank you.
Thank you, Your Honor.
Mr. Finling, if you'd like to submit a proposed bond modified order, where we can do it at that point.
I will,
With the
Judge.
provision that he needs to come, please explain, he needs to come down to the clerk's office, J150, if he changes his address. Okay?
Okay, got it, Judge. And I just want to make sure that they have 25B. That was the apartment for that Flint River address. It was a 681 Flint River apartment 25B.
That's what we have.
Okay.
30238.
Yes.
It also
Thank you.
appears that he's on first offender's probation in Clayton County for theft by take-in.
Yeah, but I'm still staying with the 3,000 signature bond through the jail. All right, thank you. All right, courtroom 2, who do we have, please?
Okay, we're gonna go back to position number 8, Mr. Jason Davis, Your Honor. Position
All right, understood. Mr. Finling, we are going to resume with your client, Mr. Davis, after your conference. Mr. Davis, just to remind you, you have a right to remain silent, and that your attorney is Mr. Finling.
Judge.
So I understand that I was arraigning the case. What's going on now?
Yes, Judge. I did speak with Mr. Davis. I'd feel most comfortable having more time to discuss his options. So I do want to reset this case, Judge. I feel like it'd be best.
All right, we can arraign the case today and he can enter a plea of not guilty, and I can reset it for next Thursday to consider a possible plea if there is a plea offer on the table. Right now, the plea is 12 months to serve. Mr. Davis, do you understand?
Yes.
Mr.
All
Davis, I would want to, I think it's best to plead not guilty today, and then I'll come visit you and we can further discuss that guilty plea for next week.
Okay.
So as I was saying, Mr. Davis has been accused of reckless conduct from an incident date of August 18, 2020, allegedly in Fulton County, Georgia. And do you waive a reading of the accusation, Mr. Finley?
Yes, Judge.
Upon your entry of a not guilty plea, the case will be scheduled for trial in the future, but presently you will also have an opportunity to discuss with your attorney a possible plea offer if another one is made from the state. But in the meantime, this case will be scheduled for trial where the state has the complete burden to prove the charge against you beyond a reasonable doubt. If that happens, then you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. How do you plead, Mr. Davis?
Not guilty.
Your case has been arraigned, but I will reset it to March 10th. Miss Katrina Lewis popped up. Is March 10th a good date?
Yes, Judge, that's
All
perfect.
right.
I just have an announcement about the interpreter, that's all.
All right, please. Yes, what's the announcement?
The interpreter, she's in another courtroom right at this time, so I was just letting you know if you want to take that special interpreter case last, that'll be fine, because she doesn't know how long she'll be with Judge Airline at this time.
We will hold until she's available. Thank you.
Okay.
All right, Mr. Davis, we'll see you next Thursday for a possible plea hearing. Thank you.
Thank you. Mr. Finley, your client, Mr. Coulter, needs to speak with you before he takes a stand.
Okay.
22392.
No problem.
All right, 5 and 6 will be in conference. Do we have any cases for Miss Helen?
Yes, and we're going to go to position number 22, Mr. Adonis Mosley.
Thank you. Mr. Adonis Xavier Mosley is accused of reckless driving, driving without a valid license, DUI, driving under the influence of alcohol less safe, in case 17 CR 025805Y, allegedly occurring in June of 2016 in Fulton County, Georgia. Mr. Mosley, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. I understand this is going to be a negotiated plea.
That's correct, Judge.
All right. Mr. Mosley, may I place you under oath for purposes of this plea hearing?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. All right, Ms. Duncan.
Yes, Your Honor. As you're aware, these incidents took place on June 14, 2016. This is a negotiated plea. And we're recommending that the reckless driving merge, and for the driving without a valid, with the DUI and the driving without a valid license, we're asking for 12 months to serve, 16 days credit for time served, 8 days balance probated, and a $500 fine. For the DUI, we're asking for 12 months to serve, 16 days credit for time served, 8 days balance probated, a $300 fine, alcohol, drug evaluation and treatment course, 40 hours of community service, a victim impact panel, and one second, let me just clarify our last condition, if you give me just a second. I'm sorry, Your Honor, so many abbreviations. I just want to make sure I'm saying the right thing before we put it on the record.
So I have risk reduction, alcohol and drug evaluation treatment, 40 hours of community service, and one victim impact panel. Is that correct?
Yes, that's correct. My apologies.
No problem. I know this whole list of acronyms there. Yeah, no problem. Okay. And this is a negotiated plea, so it would be pleading to 2 counts instead of 3. Ms. Helen, is that your understanding?
Yes, Judge, that is our understanding that the reckless will merge into the DUI as well as the conditions listed. We agree with the state's recommendation and we stipulate to the factual basis, venue, and ID. We would just ask if 3 months of the probation fees can be waived.
March, April, May?
Yes, Your Honor.
Okay. Anything else?
That's it, Judge.
Oh, and we stipulate to the factual basis, venue, and ID. I think you said that, sorry. Okay. Mr. Mosley, from what I've gathered, you would be entering a guilty plea to 2 of the charges, which is DUI and failure to have a valid license while operating a motor vehicle. Is that your understanding?
Yes, Your Honor.
All right. First of all, have you consumed any drugs or prescription medication or alcoholic beverages that may impair your ability to think clearly?
No, ma'am.
And are you satisfied with the representations that you received from Ms. Helen?
Yes.
Is anyone forcing you or inducing you to take a plea today?
No.
And if you decide to plead guilty to these charges, you have to waive your constitutional right to go back to court in the future, to have a trial before a judge or a jury, to have the assistance of counsel to challenge the state's case, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of DUI, driving under the influence of alcohol less safe?
Guilty.
How do you plead to 1 count of driving without a valid license?
Guilty.
The reckless driving will merge into the DUI. For the DUI, it's 12 months to serve, 16 days, credit for time served, 8 days. That time is concluded for the jail, so you'll be placed on probation. You have to report to probation no later than Tuesday morning. And once you're on probation, you will pay a $300 fine, complete a risk reduction program, complete 1 alcohol and drug evaluation, and submit yourself to any treatment if required. You will also complete 40 hours of voluntary community service and attend 1 victim impact panel. The driving without the valid license sentence will be concurrent to the DUI, with the exception that you have to pay an additional $500 fine. Your probation fees shall be waived for March, April, and May. You will continue to report to probation for the rest of your probation time. And you are required to pay the $800 fine plus all court costs and probation fees beginning June 1st, 2022. Do you understand, sir?
Yes, ma'am. Will I have all this like in writing so I know?
Yes, not only will you have it in writing, but every time you visit your probation officer, you can have them explain it to you all over again.
All right, thank you.
Thank you.
All right, next we have position number 2, Mr. Bivens.
We have Makia Jaheem Bivens at 4 South. And how shall I address you, Mr. Bivens? Hello, I can't see you. I'm so sorry. You're in the shadow. Are you Mr. Bivens?
Yes, ma'am.
All right. Mr. Bivens, case number is 21 CR 001251F. Mr. Bivens, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. And is it going to be Mr. Finley?
Yes, Judge. Is Mr. Bivens number 2?
Yeah.
Yes, yes,
Okay.
Judge. That's me.
All right. Mr. Bivens is accused of 1 offense of simple battery domestic violence from March 13, 2021. And I understand that he will be entering a plea of not guilty and have the case scheduled for trial. Is that correct?
That's correct, Judge.
All right. And do you waive a reading of the accusation?
I do.
Mr. Bivens, you've been accused of 1 charge of simple battery domestic violence. You are presumed innocent in the eyes of the law until the case goes to trial, where the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state succeeds, you could be convicted of this offense and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead? Mr. Bivens, can you hear me?
Can you say that one more time, please?
Sure. Mr. Bivens, you have been formally accused of a misdemeanor offense of simple battery domestic violence from an incident date of March 13, 2021. Upon your entry of a not guilty plea, your case is going to be scheduled for trial. At the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. You will have the assistance of counsel to challenge the state's case. However, if the jury or the judge finds you guilty and you are convicted of said offense, you could face a penalty and a sentence of up to a year in prison and or up to $1,000 fine. Given this information, how are you pleading presently?
Guilty.
All right. Your case has been arraigned and is going to be further noticed for trial. Presently, you do have a bond for this charge, and your attorney is going to seek a modification. Mr. Finley?
Yes, Judge. For Mr. Bivens, currently his bond is set at a $5,000 surety bond, of which he cannot afford, Judge. Mr. Bivens is 18 years old. He is a young man. He's working on his GED. His mother and all of his family live in Atlanta, so he does have strong community ties. I really stressed to him the importance of returning to court, and as we know, bond is not punitive, but meant to ensure his return to court. So we are asking for a signature bond in this case, Judge, or if not inclined, a bond not exceeding $1,000.
Ms. Goodry?
Yes, Your Honor. We do understand that this is a simple battery family violence and he has a $5,000 surety. We would be in agreement with the $3,000 surety. However, we do state that a surety bond is appropriate in this case, given that he has an open charge for terroristic threats, disorderly conduct, criminal trespass, and willful obstruction from February 9th of this year, where he was given a $19,000 surety bond. Also, he was given, in this case, a SOB through pretrial by Eric Morrow, but pretrial was released after he was arrested on the new charges. So given the new charges and that he was also given a $19,000 surety bond in that case, we think that a $3,000 surety bond is appropriate in this manner.
Bond amended to $1,500, surety bond with all conditions remaining, no contact with victim, no illegal drugs, no alcohol, and no weapons.
Okay.
Thank you, Judge.
Thank you, Mr. Bivens. The bond's modified to $1,500. And next case, please.
Got position number 4, Mr. Terrence Cody, position number 4.
Mr. Terrence Cody is accused of loitering and prowling from May 15, 2021 in case number 21 CR 002-387D. Mr. Cody, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finley. In this particular case, I understand this is going to be a negotiated plea. Mr. Cody, if you'd like to raise your right hand, please, for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Goodry, what's the recommendation?
The recommendation is 12 months, 160 days, 80 days credit for time served. The balance is suspended. No further contact with Jennifer Clifton, common spelling. A stay away from 733 Peg Road, Atlanta. And no further violations of Georgia law while on the suspended sentence. And if defense stipulates to the factual basis, venue, and ID, we have nothing further.
You mean if he gets arrested again, his probation could be revoked? I mean, he could be arrested again?
Yes, that's
But
correct.
it won't have any impact on this sentence, right?
That's correct.
Okay. Mr. Finley?
Yes, Judge Law. We do agree to the state's recommendation. And additionally, we do stipulate to the venue, factual basis, and ID, Judge.
All right, thank you. Mr. Cody, are you under the influence of any kind of drugs or alcoholic beverages?
Oh, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes.
If you decide to plead guilty to this charge, you would have to give up your right to go back to court to have a trial before a judge or a jury. to challenge the state's evidence, to confront your accuser, examine witnesses, and have the state try and prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you being forced to take this plea today?
No.
How do you plead to the one count of loitering and prowling?
Guilty.
Your sentence is time served. The balance is suspended. If you have no other holds at the Fulton County Jail, you'll be released within 24 hours. Do you understand?
Yes.
And once you're released, you are to stay away and have no contact with Jennifer Clifton, and to stay away from 733 Peg Road in Atlanta, Georgia. If you return to 733 Peg Road, the owner of that property can always contact the police and have you arrested again and charged with criminal trespass.
Okay.
Do you understand?
Yes, ma'am.
All right. And you are not to contact Miss Jennifer Clifton and Miss Goodry. If I don't see Miss Clifton here, but if victim advocates can reach out to her, as this is a balance suspended, she would need to seek a Superior Court protective order as well if she believes that there is some kind of imminent threat.
Okay.
All right. Thank you.
We got position 5 and position 6, Mr. Coulter.
All right. Mr. Richard James Coulter Jr. is accused of one count of battery domestic violence in 2 separate cases. Case 20 CR 003227E from a May 9th, 2020 incident. And in case number 21 CR 007684E from a December 15th, 2021 incident. As I understand it, Mr. Coulter is planning to enter a plea. The question is it a negotiated or non-negotiated plea?
It's a non-negotiated plea, Judge. And he also wanted me to see if he has a NOLO available. He wanted to plead NOLO.
All right. He can plead NOLO to one of the charges if he qualifies. Ms. Harrison, has Mr. Richard James Coulter pled no contest to any battery charges in the last 5 years?
Now, Your Honor.
All right, thank you. Okay, Mr. Coulter, we are first going to hear from the prosecutor, Ms. Goodry, and she's going to set forth the recommended sentences for both cases and also state the alleged factual basis for each case in order to argue for their recommendation. I will then hear from your attorney as to the alternative recommendation. I will make a decision as to which recommendation I will accept, and I will let you know before you proceed with your decision to enter a plea. Do you understand?
Yes.
All right, and Mr. Coulter has already been advised of his right to remain silent. So, Ms. Goodry?
Yes, Your Honor. For docket number ending in 227E, which is position 5, we're recommending 12 months to serve, 154 days, 79 days credit for time served. The balance is probated. FVIP, no further contact with Candace Morris, common spelling. A stay away from 29 Lakeview Place, East Point. No alcohol, drugs, or weapons, and 60 hours of community service. The issue in this case is the community service. What happened in this case was that the defendant forced his way into his niece's bedroom in which she was living in with him. He forced her into a corner. After pleading with him, he pushed her onto the bed and began punching her in the head and face area, busting her lip. She then grabbed the defendant's phone to call her mom. She went into the restroom where he then followed her and then pushed her into the bathtub, causing her to hit her knee and where she sustained a laceration to her right knee. And again, at that time, the parties did live together at that location. For this case, we do state that 60 hours of community service is sufficient given the extent that he has 2 open battery cases. And his criminal history consists of 19 arrests dating back to 1994. Although he has no battery convictions, he does have 2 convictions, 2 pending battery family violence cases open. In the second case, 684E, position 6, we're recommending 12 months to serve, credit for time served, 154 days, 77 days credit for time served. The balance is probated. FVIP, no further contact with Lovey, Luvey, Burks, common spelling. A stay away from 38 Lakeview Place, East Point, no alcohol, drugs, or weapons, and 60 hours community service. In this case, the issue is the stay away in the community service. In this case, Ms. Lovey Burks was the girlfriend of the defendant. The defendant, for some reason, got upset and wanted to kick her out of the apartment. He put her personal belongings outside of the door. Belongings out of the door. He charged at her in the bedroom. Ms. Burks was holding a glass cup in her hand, and when the defendant pushed her into the wall, the glass cup broke, cutting her on her right arm. Again, Your Honor, this is the second battery family violence within 2 years. The community service is sufficient in this case. As for the stay away, we tried to attempt to contact Ms. Burks. However, we were unsuccessful on 2 accounts. So we do not know whether or not she still lives there. And if she does live there, I believe that a stay away is sufficient. So that's why we asked for the stated recommendation for the community service and the stay away.
All right. And just a couple of questions before we move on to the defense. This is going to be a concurrent sentence for both cases?
That is correct.
So the 6-month domestic violence intervention program, he only needs to do that one time for both cases.
Mm-hmm.
And the 60 hours of community service, are you all asking for a total of 120 hours or 60 hours to be applied to both cases?
60 hours to be applied to both cases.
All right. And the location, 29 Lakeview Place and 38 Lakeview Place appear to be in the same neighborhood or thereabouts. So I'm assuming he cannot return to both properties. He may return to one if Ms. Burks does not occupy 38 Lakeview. Is that correct?
That's correct.
All right. Okay. Understood. All right, Mr. Finley?
Yes, Judge Law. Mr. Coulter is 68 years old. He has no car and no driver's license. So in regards to the community service, I do understand where Ms. ASG is coming from. Regarding 60 hours community service, I'll only say that Mr. Coulter is closing in on his 70th birthday. He doesn't move entirely well. He has no license and he has no car. Just taking all those things into account, that is why we were asking for no community service. That is, it would just be very difficult for him at his age with no transportation, being on his feet. So that's why we were asking for that to be removed, Your Honor. And then regarding for moving on to position 6, regarding the 38 Lakeview Place, Mr. Coulter stated that is his residence and that Ms. Burks no longer lives there. So yeah, so she is no longer at that 38 Lakeview Place, Judge. And that's why we're opposing that stay away.
And Your Honor, can we request a one-time escort just to ensure that she isn't there, just in case?
Yeah, I don't have a problem with that.
Okay.
Mr. Coulter, I do appreciate the argument about your age and the lack of transportation. And you will have almost 6 months to complete 60 hours of voluntary community service, which can be paced out over 6 months, 10 hours a month, 15 hours a month, however you like it. And I am going to require you to do the voluntary community service. And you can return to 38 Lakeview Place in East Point as long as Ms. Lovey Burks does not occupy the property. And the only way we will ascertain that is if once you are released, you can return to the property for the first time with a police officer. If the police officer ascertains that Ms. Burks is still living there, you would need to find an alternative place to stay. So do you still want to proceed with the plea?
Yes.
All right. And Mr. Finling, do you stipulate to then venue and ID?
Yes, Judge.
All right. I'm going to waive all probation fees, but let's proceed with this first. Mr. Coulter, for both cases, I'm going to have to make a decision as to whether you are going to enter a plea of no contest for the first count of battery domestic violence, and then a guilty plea to the second count of battery domestic violence, and that you're doing so willingly, knowingly, and voluntarily. Do you understand?
Yes.
And with regards to the May 9th, 2020 incident and the December 15, 2021 incident, so far, have you understood everything that's happened during the course of this proceeding?
Yes. No.
Are you under the influence of any kind of prescription drugs or alcohol that may impair your ability to think clearly?
No.
Are you satisfied with the representation you received?
Yes.
If you decide to plead no contest and guilty to these two charges respectively, you would have to give up your constitutional rights to go back to court in the future, have a trial before a judge or a jury, have the assistance of counsel to challenge the state's evidence, present your own defenses, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Is anyone forcing you or inducing you to take a plea today?
No.
How do you plead to battery domestic violence from the May 9th, 2020 incident involving one Candace Morris?
Guilty. Guilty.
Is that the count you want to plead guilty to?
Yes, count, I won't plead guilty.
Okay. And how do you plead to one count of battery domestic violence from the December 15, 2021 incident involving one Miss Lovey Burks?
No.
All right.
No prior nolos, Your Honor.
All right, so he has a right to enter a nolo plea for position 6 and a guilty plea to position 5. Your sentence for both cases are going to be concurrent. Your probation fees shall be waived. You must report to your probation officer no later than next Tuesday at 132 Mitchell Street. Do you understand, sir?
Yes.
You will report to probation every month. And while you're reporting to probation, you will complete a 6-month domestic violence intervention program at your expense. You'll be required to enroll in that program within 30 days of being released. You also to complete 60 hours of voluntary community service, and you may complete that during the remainder of the time that you have on probation. At all times, you are to have no contact with Candace Morris. You are to stay 200 yards away from Candace Morris, as well as no contact with Lovey Burks. You're not to communicate with them in person, not communicate with them through any kind of cell phone, electronic device, not on any social media, and definitely not through any third person. You're to stay 200 yards away from 29 Lakeview Place in East Point, and you can return to 38 Lakeview Place, East Point, as long as Ms. Burks does not occupy those premises. If she's occupying those premises, you can return one time only, first time only, with a police officer to verify that she's not living there. If she is living there, you would need to find alternative living arrangements and update your address with us within 30 days of being released. You can, of course, use the dispossessory court proceedings to remove Ms. Burks if she is living there and you are the owner of the property. Do you understand?
Yes.
All right. Do you have any questions, sir?
I just have one thing, that the address you have is wrong. It's 3,200 instead of 3,800 you have.
Repeat.
The address you have is incorrect. The actual address is 3,200 Lakeview Place.
Where Miss Burks is living?
She doesn't live there. She lives at 2,900. That's where she lives. I live in 3,200 Lakeview Place. She doesn't
All
live.
right. You can go back to your home, but if Miss Burks is living in your home and the police officer verifies that, you cannot enter that premises. You understand?
I understand.
All right. Good luck, sir.
Yep.
We got position 25, Mr. Riley, position 25.
Clifford Riley is accused of simple battery in 17 CR 023-981A. Alleged incident is September 29, 2015. Mr. Riley, you've been advised of your right to remain silent, and your attorney is Patrice Helen. For purposes of this plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? All right, thank you. Ms. Duncan, what is the plea recommendation?
Yes, Your Honor, the state is recommending 12 months to serve, 18 days, credit for time served, 9 days, balance probated, a 6-week anger management course, and no further contact with the victim in this case. Her name is
Kiera Coleman.
Yes, Kiera Coleman.
All right. Thank you. Ms. Helen, do you stipulate to factual basis venue and ID?
I do, Your Honor, and we agree with the state's recommendation. We would just ask if at least 3 months of the probation fees can be waived, and that once he completes the 6-week anger management courses, it go non-reporting, Your Honor.
Any objection to non-reporting, Ms. Duncan?
No objection.
All right. Mr. Riley, are you under the influence of any kind of drugs or alcoholic beverages?
No, ma'am.
Are you satisfied with the representation of your attorney, Ms. Helen?
I am.
Is anyone forcing you to take a plea today?
No.
If you decide to take this plea, you would have to give up your constitutional right to have a trial before a judge or a jury, to confront your accuser, examine witnesses, present evidence to challenge the state's case, and as well as present your defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to the 1 count of simple battery?
Guilty.
Your sentence is 12 months to serve 18 days, credit for time served 9 days. You'll be released within 24 hours if you have no other holds at the jail. You'll report to probation by next Tuesday morning. And while you're on probation, you will complete 6 weeks of anger management classes. And at all times while you're on probation, whether it's active or non-reporting, you have to have no contact with Kiera Coleman, which means staying 200 yards away from her. Do not communicate with her in person through any kind of electronic devices, through social media or third party. Do you understand, sir?
Yes, ma'am.
And your probation fees are waived for the months of March, April, and May. Any questions?
No, ma'am.
All right, that concludes your case.
We got position 26, Mr. Rivers, position 26.
Sorry, thank you, April. We have Cornelius Rivers accused in 22 CR 0000823C of criminal trespass and loitering and prowling from a February 16, 2022 incident. Mr. Rivers, you have a right to remain silent, as I've already explained, and you are represented by Ms. Patrice Helen. For purposes of this plea, may I place you under oath? Mr. Rivers, hello, good morning. Are you awake? Hello?
Yes.
I can't hear you. Young man, are you awake?
Yes.
Yes.
All right. What's your name?
Cornelius Rivers.
Repeat.
Cornelius Rivers.
Okay. Mr. Rivers, your case is 22 CR 00823C. You're accused of criminal trespass and loitering and prowling from February 16, 2022. Your attorney is Ms. Helen. May I place you under oath?
Yes.
Do you solemnly raise your right hand?
Right hand.
Do you solemnly swear and affirm the testimony?
Keep it up. You got to keep it up until you finish.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, if you fall asleep, I'm going to stop the hearing and see you next week. Put your hand down and pay attention. Ms. Duncan, what's the recommendation for Sleepy Rivers?
The recommendation from the state is 12 months to serve, 32 days, credit for time served, 16 days, balance probated, 40 hours of community service, and a stay away from the incident location, which is 370 Northside Drive Northwest, which is the gateway at Northside Village.
Was he a applicant or a resident at that facility?
He was trespassing on that property, and that's what we have listed. Miss Helen, do you have something different?
Judge, I don't have anywhere, I don't have where he was arrested. I don't know if he was arrested at the 370 Northside Drive.
Oh.
That's just the only
Just one second. Mr. Finling, is your client who needs an interpreter present?
Trying to see if I can.
Sound out for him.
Mr. Felix Castro. I do not see him.
Is that Mr. Castro in the front seat of the bench?
Oh, yes, there you are.
Okay. And who is our interpreter this morning? Our interpreter is still in another court.
It's not on the line yet, Judge.
Okay, so we can't do anything until he or she appears. All right. All right, I'm sorry, Ms. Duncan, anything else?
I was just gonna say the warrant does say 370 Northside Drive, damaged the lock on the door of apartment 1416.
Okay. All right, Ms. Helen?
Yes, Judge, this is a negotiated plea, and we do stipulate to the factual basis, venue and ID. We would just ask for the first 3 months of the probation fees be waived for Mr. Rivers. And I don't know if it was mentioned, but there is a no contact with Miss S. Quinn. So I just wanted to make sure we had that clear for the plea paperwork.
Yes.
Is that Miss Esquin? Is that the complete name I have?
I can't pronounce the first name, but the last name is Quinn. First name is Shakayzha.
And the last name is Quinn.
Correct. Quinn.
All right. Okay. Mr. Rivers?
Yes.
Are you awake?
Yes.
And have you taken any kind of prescription drugs or alcoholic beverages?
No.
Have you understood the proceedings so far?
You're supposed to be time served, correct?
Have you understood the proceedings so far?
Yes.
Have you understood the explanations that your attorney has given you about this hearing?
Yes.
And are you satisfied with her representation?
Yes.
Are you prepared to give up your right to go back to court, to have a trial before a judge or a jury, to confront your accuser, challenge the state's case, present your defenses, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt?
Yes.
Did you understand all the rights that I've just listed?
Yes.
And you're giving them up?
Yes.
Is anyone forcing you to take a plea today?
No.
How do you plead to 1 count of criminal trespass and loitering and prowling?
Guilty.
Your sentence is 12 months to serve 32 days, credit for time served 16 days. Your time at the jail is concluded for this case. You'll be placed on probation. Once you're on probation, you must complete 40 hours of voluntary community service, and you need to stay away from the Gateway Village, 200 yards away. That's the length of 2 football fields. You understand? Hello, Mr. Rivers?
Yes.
Did you understand you have to stay away from Gateway Village?
Yes.
And when do you have to report to probation?
First thing next week.
No later than next Tuesday.
Okay.
All right, give probation your mailing address and all the contact information, otherwise you come back to jail.
Your Honor, also to stay away from Miss Quinn.
Oh, yeah. Do you know a Miss Shakayzha Quinn?
Yes.
You cannot have any contact with her. You cannot communicate with her in person through any kind of phone or computer, nor through any third party or social media. Do you understand that?
Yes.
Okay, that concludes the case.
Yes,
Thank you,
yeah.
Judge.
32, Mr. Terry.
Come on.
Judge, the Spanish interpreter is on the line now.
Thank you. Mr. Finling, who's our interpreter? Miss Lucia, good morning.
Good morning, Your Honor.
All right. Is there a way that we can place you on a group call to the jail? Mr. Finling?
Yes, yeah, that would be great.
All right. So Miss Lucia, if you can send your phone number to Mr. Finling on the chat.
Yes.
And
Yes,
then
Your
he
Honor.
will contact the jail to have Mr. Felix Castro, yourself and him on a group call at the jail facility to discuss that case. And I'm sorry, Deputy in courtroom 2, who was your next case?
32, and on 4 North.
All right. We have Khalil Terry, accused of 1 count of disorderly conduct and a 2nd count of disorderly conduct of property from a February 28, 2020 incident, case number 22 CR 0000863A. Mr. Terry, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Ms. Catrice Helen. This is going to be a negotiated plea. Is that correct?
That's correct, Judge.
All right. Mr. Terry, please raise your right hand for the purposes of the plea. Do you solemnly swear and affirm the testimony provided will be the truth to the best of your knowledge?
I do.
All right.
I do.
All right. I hear you now. Thank you. Mr. Segura, we have 2 counts of disorderly conduct. Is this going to be a concurrent plea recommendation?
It is.
Okay. And what is it, please?
The state is asking for 12 months to serve 28 days, credit for time served 14 days, the balance probated, a mental health evaluation, and a stay away from Tropical Smoothie Cafe, located at 2275 Marietta Boulevard, Suite 100, and no further contact with Alicia Butler, spelled E-L-I-S-H-I-A, Butler, common spelling.
All right. Ms. Helen?
Yes, Judge, this is a negotiated plea. We are agreeing with the state's recommendation. We do stipulate to the factual basis, venue, and ID. We would just ask for the first 3 months of that probation fees to be waived, and that once he does get that MHET, it go non-reporting, Your Honor.
All right. And has it been explained to him what an MHET is?
Yes, Your Honor, and that he will have to arrange for that himself.
All right. Thank you. Mr. Terry, have you taken any prescription drugs or alcoholic beverages at the present time?
No, I have not.
And have you understood the proceedings so far?
Yes, I do.
Are you satisfied with the explanations that you received from Ms. Helen?
Well satisfied.
All right. And Mr. Terry, if you decide to take this plea today, you would have to waive your constitutional rights to go back to court, to have a trial before a judge and a jury, excuse me, to have the assistance of counsel to challenge the state's case, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Is anyone forcing you to take a plea today?
No one.
How do you plead to 1 count of disorderly conduct and 2nd count of disorderly conduct at a property?
Guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. Unless you have any other cases holding you at the jail, you should be released within 24 hours. Once you're released, you must report to your probation officer no later than Tuesday morning next week. Understood?
Yes, ma'am.
Your probation fees shall be waived for March, April, and May. And while you're on probation, which you'll be reporting to them every month, you are to complete a MHET. Do you understand what that program is?
Yes, ma'am.
And at all times while you're on probation, you are to stay away from the Tropical Smoothie Cafe, at 2275 Marietta Boulevard in Atlanta, Georgia. You're also to not have any contact with Alicia Butler. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. Understood?
Yes, ma'am.
All right. Were we going non-reporting on this one after the MHET?
Yes.
All right. Mr. Terry, if you complete the MHET and no treatment is required, then your probation may be non-reporting. Do you understand, sir?
Can you repeat that?
When you report to probation initially, you will be reporting in person. One of the conditions of probation is that you have to complete a MH evaluation and submit yourself to any treatment if required. If you've completed the evaluation and/or all treatment that's imposed, then your probation may be non-reporting. But until that happens, you must report in person.
Understand?
Do you understand?
Yes, ma'am.
All right. Do you have any other questions about your sentence?
No, ma'am, I do not.
All right. That concludes your case. Good luck, sir. Courtroom 2, who do we have, please?
We got position number 29, Mr. Shannon.
Mr. Ricardo Shannon, case number 22 CR 0000845F is accused of disorderly conduct from February 17, 2022. Sir Shannon, you have been advised of your right to remain silent, and your attorney is Ms. Patrice Heller. This is going to be a negotiated plea, so for purposes of this hearing, may I place you under oath?
Yes, ma'am.
You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
Thank you. Mr. Segura, what's the plea recommendation for this case?
The state is recommending 12 months to serve 30 days, credit for time served for 15 days, balance probated, a mental health evaluation, and a stay away from La Quinta, located at 575 Old Holcomb Bridge Road, Roswell.
Thank you. Ms. Helen?
Yes, Judge, this is a negotiated plea. We do stipulate to the factual basis, venue, and ID. We are just asking for those first 3 months of that probation be waived, and that once he has completed and received the mental health evaluation and treatment, it go non-reporting.
All right. Any objection to non-reporting, Mr. Segura?
None.
Okay. Mr. Shannon, have you consumed any prescription drugs or alcoholic beverages recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Have you spoken to your attorney? Are you satisfied with the representation?
Yes, ma'am.
If you decide to plead guilty to this particular charge, you will have to complete an MH evaluation and any treatment that's required. And you need to stay away from the La Quinta Inn. Would that be a problem?
No, ma'am.
If you decide also to take this plea, you would have to give up your constitutional right to have a trial before a judge or a jury, to confront your accuser, examine witnesses, have the assistance of counsel to challenge the state's evidence and present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of disorderly conduct?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other cases holding you, you'll be released within 24 hours and placed on probation. You will report to probation no later than next Tuesday morning. While on probation, you will complete a MH evaluation and submit yourself to any treatment that's required. Your probation fees shall be waived for March, April, and May. And if you've completed the evaluation and/or treatment that's required, then your probation will be non-reporting. Until then, you must report in person. Do you understand, sir?
Yes, ma'am.
And you cannot return to the La Quinta Inn at 375 Old Holcomb Bridge Road?
575.
575. Okay. Any reason that you need to go back, Mr. Shannon?
No, ma'am.
All right, if you return to that location, whether it's the parking lot or the lobby, they will have you arrested again. Do you understand?
Yes, ma'am.
All right, good luck, sir. Your case is concluded.
Thank you so
Thank you,
much.
Judge.
Thank you. All right, Mr. Felix Castro, please. I'm sorry, officer, I want to take up the interpreter case, please.
Okay.
Thank you. And why can't I find this case? Oh, position 11. And 12. Ms. Lucia, do you mind, please? Do you solemnly swear and, yeah. no
Sorry, I
problem.
was muted.
Do you solemnly swear and affirm that the translation you provide from English, Spanish, and vice versa will be a true and accurate translation with no changes or embellishments?
I do.
Thank you.
And Ms. Lucia, can I have your first and last name, please?
Yeah, it's Lucia, and the last name is URTUSASTEGUI.
Thank you.
Do you mind if I call you Ms. Lucia?
That's fine, Your Honor.
Thank you. All right. With regards to Mr. Bienvenido Felix Castro, he's got 2 cases before us.
En cuanto al señor Bienvenido Félix Castro, tiene 2 casos enfrente de esta corte.
First case is 10 CR 364056, charged with no driver's license and obstruction of an officer from May 2010.
La primera acusación es de enfrente de un agente de policía. Can you repeat the date for the interpreter, Your Honor, please?
The date was May 13, 2010.
Del 13 de mayo del 2010.
The second case is 10 CR 365976, charged with obstruction of an officer from May 19, 2010.
El siguiente caso es de obstrucción a un agente del 19 de mayo del 2010.
Mr. Felix Castro has a right to remain silent about the facts of the case. Any statements he makes, those statements can and will be used against him. He has a right to an attorney, and representing him is counsel Zach Finley.
El señor Félix Castro tiene el derecho de permanecer en silencio porque cualquier cosa puede ser usada en contra de él. Y el segundo derecho que tiene es el derecho a un abogado. Y el señor Zach Finley es el abogado que le ha sido asignado.
Mr. Finley, how are we proceeding with these 2 cases?
Yes, Judge. These will be a negotiated plea.
La juez le pregunta al abogado cómo están procediendo por estos 2 casos y el abogado contestó que era un acuerdo negociado.
Please raise your right hand, Mr. Felix Castro, to be placed under oath for the plea.
Señor Félix Castro, por favor, levante su mano derecha para ponerle bajo juramento.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
¿Jura y afirma usted que el testimonio que nos dará aquí será la verdad basado en su conocimiento?
Sí, señor.
Yes, ma'am.
Thank you.
Puede bajar la mano, gracias.
Ms. Goodry, is this going to be a time served on all counts, running concurrent and no driving?
Yes, that's correct, Your Honor.
All right.
For position 11, it's 12 months, 36 days, 18 days credit for time served. The balance is suspended. No driving unless he is licensed. And for the obstruction, it will merge and it will be concurrent with position 12. I don't want to talk too much. For position 12, it's 12 months, 36 days, 18 days credit for time served. The balance is suspended as well.
Ms. Lucia?
La fiscalía está dando esto para la negociación. Por la cuenta número 1, por la acusación número 1, son 12 meses y 36 días y el balance en la cárcel y el balance suspendido. No puede conducir sin tener licencia de conducir. Para la segunda cuenta, para el segundo acusación y el segundo cargo, la sentencia es 12 meses y 36 días. Nuevamente, 10 días, lo demás es suspendido.
For position 11, I've got time served for the obstruction of an officer, or is the state merging that?
That is merged, so it will be time served as well.
Well,
Las
if
do-
you,
Sorry.
I'm sorry, go ahead. Go ahead. Ms.
Las dos acusaciones van a ser, los dos cargos van a ser negociados a el tiempo que ya ha estado usted sirviendo encarcelado.
It's just semantics, but if you merge it, then he's pleading to one count in position 11. But if it's time served, then it's pleading to 2 counts. No driver's license and obstruction.
It can be merged, that's fine.
Thank you.
You're welcome.
Ms. Lucia, did you want to translate that?
Yes. La juez había dicho que si es que nada más se une lo de no licencia con la otra, es nada más un caso y una declaración culpable. Y eso es lo que la fiscalía está diciendo que puede hacer.
Mr. Findling, are these the terms to which your client has accepted?
Yes, Judge, we do agree to the state's recommendation.
And you stipulate to factual basis, venue, and ID?
Yes, Judge.
Y la juez le pregunta a su abogado si es que su abogado está de acuerdo con lo que le dijo la fiscalía y el abogado dice que sí, que esos son todos los términos de los que ustedes han acordado.
Mr. Felix Castro, have you consumed any drugs or alcoholic beverages?
Señor Félix Castro, ¿ha consumido usted alguna droga o bebida alcohólica?
No, señora.
No, ma'am.
Have you understood the proceedings so far?
Hasta este momento, ¿entiende usted estos procedimientos?
Sí, señora.
Yes, ma'am.
Are you satisfied with your attorney, Mr. Findling?
¿Está satisfecho usted con su abogado, el señor Findling?
Sí, señora.
Yes, ma'am.
If you plead guilty to 1 count of no driver's license and 1 count of obstruction of an officer in the second case, you would have to give up certain constitutional rights.
Si es que usted se declara culpable a la acusación de no licencia y a la acusación de obstruir a un agente de policía, usted estará, al declararse culpable, está negando ciertos derechos que tiene usted, que le vamos a decir cuáles son.
Those rights include a trial before a judge or a jury.
Esos derechos incluyen un juicio en frente a un juez y a un jurado.
To confront your accuser and examine witnesses.
Para poder confrontar a su acusador y examinar a testigos.
To challenge the state's evidence and present your defenses.
Para ir en contra de la evidencia que tiene la fiscalía y presentar su propia evidencia.
And to have the state try to prove the charges against you beyond a reasonable doubt.
Y también que el Estado, la fiscalía, pueda comprobar las acusaciones en contra suyo más allá de una duda razonable.
Are you prepared to give up these rights?
¿Está preparado usted para renunciar a estos derechos?
No? Sí?
Sí, señora.
Yes, ma'am.
Mr. Felix Castro, how do you plead to 1 count of no driver's license in position 11?
¿Cómo se declara, señor Félix Castro, por el cargo de no tener licencia de conducir?
Culpable.
Guilty.
How do you plead to 1 count of obstruction of an officer in position 12?
¿Cómo se declara en la acusación de obstruir a un agente de policía en el puesto número 2?
Culpable.
Guilty.
Your sentence is time served for both cases.
Su sentencia es el tiempo ya servido encarcelado para las dos acusaciones.
You should be released within 24 hours unless you have any other cases holding you at jail.
Y lo más probable es que lo van a dejar salir a usted en las próximas 24 horas, a menos que tenga algún otro caso o acusación pendiente en la cárcel.
And you cannot operate any motor vehicle unless you have a valid driver's license, adequate insurance, and proper registration.
y no puede manejar un vehículo a menos que tenga licencia de conducir válida, el seguro, aseguranza en efecto y una registración válida del vehículo.
Do you have any questions?
¿Tiene alguna pregunta?
No, señora.
No, ma'am.
That concludes this case. Thank you.
Ok, eso es todo para este caso. Muchas gracias. Your Honor, are the interpreter services needed?
I don't believe so. I believe that was the only case. Is that correct, Ms. Helen, Mr. Finley?
No more, Judge.
All right. Thank you very much. Sounds like you got a busy morning, so I appreciate you being here. Thank you.
You're welcome, Your Honor.
Thank you.
Have a good day.
I appreciate it. Thank you.
All right. Next case, please. Courtroom 2.
Yeah, position 31. Position
number
31.
20. Number 20.
Mr. Skelton.
Number 20, Mr. Martin.
He just logged in. How's he gonna just log in like that?
Doing number 20, Mr. Martin.
20. I've got position 20. Is that correct?
Yes.
Okay.
Oh, fine.
Someone competing for a position. Okay. All right. I have Mr. Antoine Martin in courtroom 2.
No, he's in medical.
Oh, on medical. Medical, then you need to appear.
Right here.
Your video is not on.
No, there's the person that kept. I see
It is, Judge. It may be on another screen, but I see medical.
Oh, there it is. It's odd. It didn't appear. Okay, sorry about that. Okay. My computer must be too small. Maybe I should ask for a larger one. So,
I'm in your
okay.
DM call photo.
All right, but are you Antoine Martin?
Yes, this is Antoine Marquis Martin.
All right, excellent. Your case number is 21 CR 008022J. Mr. Martin, you're accused of criminal trespass and damage to property from December 29, 2021. My name is Judge Law, and please remember that you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Finley. And with regards to this case, it is going to be a non-negotiated plea. A non-negotiated plea means that the prosecutor is going to let me know what is the recommended sentence for Mr. Martin, and then your attorney will let me know what should be an alternative recommendation. I will consider both the options and let you know which one I'm going to select. And then you can decide if you want to proceed with the plea. Understood?
Understood, ma'am.
Excellent. Ms. Duncan?
Yes, Your Honor, the state is recommending in this case 12 months to serve, 128 days, credit for time served, 64 days, with the balance probated, a stay away from 2936 Larchmont, LARCHMONT Court, Northwest Atlanta, an MHET, and no further contact with Keisha Probst. That's KEISHA Probst, PROPST.
And did you want to articulate the factual basis, or what are we?
Yes, Your Honor, the factual basis for this is that on December 29th, 2021, the defendant in this case who's currently on a $3,000 surety, returned back to the property after receiving several warnings to leave the property. And according to the facts, the defendant broke a window at that time. This defendant had been told several times by the victim, who is his aunt, to leave the property, as well as police to leave the property and not come back. He continued to return to the property against the advice of his aunt and the police. His aunt stated in the facts that she owns a property and he does not live there, and she does not want him on the property. This defendant has a 2017 NOLO for criminal trespass, has additional open charges, several open charges out of Jonesboro and Decatur, as well as several other arrests for criminal trespass out of DeKalb County with no disposition from May 13th, 2021, September 24th, 2021. So that's the factual basis, and we're concerned about the risk of reoffense and safety of the victim in this case, why we recommend it as such.
We have a residential challenge issue. Mr. Findling, can you address that?
Yes, Judge Law. I did cover that with Mr. Martin. Mr. Martin did give me an address, a triplex that he will be living.
What's a triplex?
I guess it's like like connected homes. That's how he said it.
Do we have an address?
Yes, it's 162 Chappelle, and that's CHAPPELL Road, and that's Atlanta, Georgia. I'm double checking what the zip code is. It's 30314.
Does he have family or relatives or caregiver?
Yes, he did say his grandma, whose name is Maddie Lee, Mattie Lee. And I did look up the address, Your Honor. It is a house, and it's Chappelle Road Northwest.
All right. And what is this defense seeking in terms of the plea?
Yes, Your Honor. We were just asking that once he does complete the MHET, if Mr. Martin could be not reporting judge.
On what grounds?
Just he did not have a car, transportation, and just wanted to limit the opportunities if he doesn't make it to be in violation of probation.
I will make it non-reporting after he completes the MHET.
Thank you, Your Honor.
And that's what we will do, as long as he stays away also from Keisha Probst and the location 2936 Larchmont Court, and that he has no contact with Ms. Probst as well. Ms. Duncan, any specific objection to placing it on non-reporting after the MHET is completed?
No, I don't believe the state has any objection to that.
All right. Mr. Martin, if you decide to plead guilty to criminal trespass causing damage to property at 2936 Larchmont Court, you will be placed on probation. While you're on probation, you need to complete a MH evaluation and submit yourself to any treatment or counseling that would be required by the provider. If you complete the evaluation and any treatment that's imposed, then your probation will be non-reporting. But until you complete that, you would need to travel and report to probation every month. I will waive your probation fees, but you will need to respond. Do you want to proceed with the plea? Do you want to proceed with the plea, or do you want a trial?
So can I ask you a question? So it's time served, probation, report, evaluation till non-report?
Correct.
All right, yes, I'll agree with the terms of the guilty.
But you need to stay away from the Larchmont Court location, and you need to have no contact with Keisha Probst. You cannot return to the location where the window was allegedly broken.
Okay, I just see my grandma over my mama's house. I don't want to see her. She can't cook anyway.
And where exactly is this house?
The same house that she stays at, that she said not to go to.
Your Honor, if I can interrupt, I spoke with the victim, Ms. Keisha Probst.
Mr. Martin.
She is the caretaker for the grandmother. The grandmother actually lives at the Larchmont address. The defendant keeps returning to their family home, asking for money. And when they refuse to give him money, he begins to damage the property. He's been criminally trespassed from that address several times. And I just want to reiterate to the court that the grandmother actually lives at the incident location. Ms. Keisha Probst is the caregiver for their grandmother.
I see. Okay.
Thank you.
But he's got a Chappelle Road.
I'm not aware who lives at the Chappelle Road. I've spoken with Ms. Keisha Probst. She is her mother's caregiver, and his grandmother lives with the victim. I can't speak to that Chappelle Road address.
Mr. Martin, is that where Kayla, I wrote down Maddie Lee and then also Kayla Probst. Is that?
They can stay with me if they need be, because Keisha, I don't know about her no more. I think she's tweaking or some shit.
Yeah, Mr. Martin. So we're just trying to figure out who stays at the 162. I thought it was Maddie Lee.
Oh no, I stay there. And I hope no sex offenders or anybody else stays there because they can stay with me, yo.
All right.
Because I'll pay for a room for them, yeah.
Okay, understood. Thank you.
What's the grandmother's name?
Maddie Probst.
Maddie Lee is the grandmother's name, Your Honor. And she lives at the Larchmont address.
And the caregiver apparently is related to Grandma Maddie as well.
Yes, that is the grandmother's daughter and the defendant's aunt.
Mr. Martin, if you decide to take this plea, you cannot communicate with Keisha Probst. You cannot see her in person. You have to stay 200 yards away. That's the length of 2 football fields from your grandmother's home. If your grandmother wants to see you, she has to travel to where you live. You cannot go to her place. You're not allowed to have a weapon or a firearm, and you cannot consume any drugs or any alcoholic beverages. You can take prescription medication if they are legally prescribed to you. Please unmute the screen.
Agree to the terms. God bless America and God bless the judicial system.
That's very nice to hear, but I just need an answer to my question.
I agree. Yes, I agree to the terms, ma'am. And did you get your glasses for probation?
Mr. Martin, just limit what you say to the judge's questions, please. Thank you.
All right.
All right, Mr. Martin, are you satisfied with the representation of your attorney, Zach Finley?
I think he needs his own, whatever. He needs something. He needs his own law firm or whatever. But tell him to chill together or something. I don't know. So he gets home.
Mr. Martin, I'm going to ask you some questions, and the response is going to be yes or no. And if you give me any,
yes, ma'am. Yes, ma'am.
No more interruptions.
Yes, ma'am.
If you don't answer the question correctly, or if you go off on some kind of explanations, I'm just going to reset this case to next week. Do you understand?
Yes, ma'am.
Have you consumed any kind of medication or alcoholic beverages recently?
My regular standard medication, ma'am.
And is this impairing your ability to think clearly?
No, ma'am, it's not, because I've been on this medication before.
Good. And is anyone forcing you to take this plea today?
Nobody's forced me to take this plea. I did this on my own accord. And if any female is watching this, you cannot get out of it. But at the same time, that's how you do that, yeah.
Again, I repeat, yes or no, and I don't need an essay question response. Understood?
Yes, ma'am. Yes.
If you decide to plead guilty to the charge of criminal trespass and damage to property, you would have to give up certain rights. These rights include the right to a trial before a judge or a jury, to have the assistance of counsel, to challenge the state's case and its evidence, to confront your accuser, examine witnesses, to have your attorney assist to argue your case to the judge or jury, and to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up all these rights?
Yes.
How do you plead to one count of criminal trespass causing damage to property?
Guilty as charged, ma'am.
Your sentence is 12 months to serve 128 days, credit for time served, 64 days. Your time at the jail facility is concluded and you will be released within 24 hours unless you have any other cases holding you at the jail. You will, if you are released, you will report to probation within 48 hours. And while you're on probation, you will complete a MH evaluation and submit yourself to any treatment that's required. I will waive your probation fees for the year, for the entire probation, but you must report to probation every month. Do you understand?
Yes, ma'am. I think I understand.
I'm not putting you on non-reporting after I've learned the information about your grandmother and your aunt. You will report to probation every month. Do you understand?
Yes, ma'am.
You are to have no contact with Keisha Probst. You're to stay away 200 yards away from 2936 Larchmont Court in Northwest Atlanta. No illegal drugs, no weapons and no firearms, and no alcoholic beverages.
Okay.
You are to have no violent contact with Maddie Lee Probst. You can have communication with Grandma Maddie, but there cannot be any physical or verbal altercations. And again,
No.
you cannot go to her home. She can come visit you. Understood?
Yes, ma'am. Yeah.
All right, that concludes this case. Thank you.
Thank you, Your Honor.
Thanks, Philly. Thanks, Philly. I'll see you later, Lopez.
Position 31, Mr. Skelton, Your Honor. Position 31.
We have position 31 in courtroom 2, and that is Mr. Cordelia Skelton, accused of obstruction of a police officer in case 20 COV 000348. Mr. Skelton, this is going to be a negotiated plea. You've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. For purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
And Mr. Segura, what's the plea recommendation?
We are recommending 12 months to serve 210 days and credit for time served for 105 days.
Balance suspended?
Yes, balance suspended.
All right, thank you. Ms. Helen?
Yes, Judge, this is a negotiated plea. That's our understanding of the plea. We are just asking, it's balance suspended. So yes, Judge, we stipulate to the factual basis, venue, and ID.
All right. Mr. Skelton, have you consumed any drugs or alcoholic beverages recently?
No.
Have you understood the proceedings so far?
Yes.
And are you satisfied with the representation you've received?
Yes.
If you take this plea today, you would have to give up your right to go back to court, to have a trial before a judge or a jury, to confront your accuser and examine witnesses, have the assistance of counsel to challenge the state's evidence and its case against you, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of obstruction of an officer?
Guilty.
The sentence is time served. If you have no other holds at the jail, you should be released within 24 hours. Thank you.
Thank you, Judge.
We got position number 33, Mr. Varner.
Mr. Tony Varner is accused of theft by shoplifting in case 21 CR 005628G. Mr. Varner, you've been advised of your right to remain silent, and your attorney is Ms. Helen. This is going to be a negotiated plea, so may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Segura, what is the plea recommendation for Mr. Varner?
My apologies. To rename the case, position
33, please. I believe it was time served and stay away from the CVS.
Yes. Don't seem to have. But yeah, it should be the stay away.
The CVS is located at 1943 Peachtree Road. Is that where you want him to stay away?
That is correct, Your Honor.
Okay, not a problem. Okay, Ms. Helen?
Yes, Judge, this is a negotiated plea. We are just asking that he be able to use his NOLO if he hasn't. And that's it, Your Honor. We do stipulate to the factual basis, venue, and ID.
Ms. Harrison, has Mr. Varner pled no contest in the last 5 years to a theft by shoplifting?
I'm checking now, Your Honor.
All right. Well, if he's not pled a NOLO, I'll accept a NOLO plea to this charge. Mr. Varner, have you consumed any kind of medication or alcoholic beverages recently?
No, ma'am.
Are you satisfied with the representation you've received?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
If you decide to plead no contest, you would have to give up your constitutional right to a trial before in a court of law, to have the representation of counsel to challenge the state's case, present your defenses, confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by shoplifting?
No.
Your sentence is 12 months to serve 74 days, credit for time served 37 days, which concludes your time at the jail. The balance is suspended, so essentially it's a time served plea. However, you cannot return to the CVS store at 1943 Peachtree Road. If you go back to that location, they will welcome you back with open arms and have you arrested for trespass. You understand, sir?
Yes.
Thank you.
Thank you, Judge.
We're in courtroom 3, position 14, Tara Greer.
We have a Miss Mary Cohen on the Zoom. Miss Cohen, are you waiting on a particular case?
Yes, ma'am. Thank you for acknowledging me. We're waiting on Mr. Hernandez, Miguel Hernandez.
Mr. Miguel Hernandez is at 11 o'clock.
You've already done?
No, it's at 11 o'clock. So.
Well, it's quarter 12.
And it's past 11. Yes, I am running late and we'll get to it as soon as possible.
Okay, thank you for acknowledging me.
Not a problem. Thank you. All right. I'm sorry. Repeat again. Courtroom
3, position 14, Tara Greer.
Thank you. Are all the 3 individuals in courtroom 3 here for the calendars?
Yes.
All right. Good morning. My name is Judge Lal, and this is the state all-purpose calendar from the Fulton County State Court. You have active criminal misdemeanor cases against you. Please remember for all 3 of you that you have a right to remain silent. Anything you say during the course of these proceedings, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, we will have counsel from the Public Defender's Office or Conflicts Defender's Office to represent you. Ms. Tara Greer, can you hear me, ma'am?
Yes.
Ms. Greer, your attorney is going to be Mr. Zach Finley. Can you see him on the screen?
Yes.
And your case is 20 COB 000360, in which you've been accused of 1 count of simple assault and 1 count of simple battery. With regards to this case, I understand that you'd like to take a plea of not guilty and have a trial in the matter. Is that correct?
Yes, ma'am.
All right. Mr. Finley, do you waive a reading of the accusation?
I do, Judge. And also this will just be an arraignment.
Okay. Ms. Greer, you've been accused of the 2 misdemeanor offenses I've just listed, which allegedly occurred on June 8, 2020 in Fulton County, Georgia. These are misdemeanor offenses to which you are presumed legally innocent until the state overcomes your legal presumption of innocence. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt. If the state succeeds, you could be convicted and face a penalty of up to a year in prison and up to a fine of $1,000 for each convicted offense. Given this information, how do you plead?
Not guilty.
Your case has been arraigned and is going to be further noticed for trial. Thank you, Ms. Greer.
Next, we have position 27 and 28, Amanda Rao.
Ms. Amanda Kathleen Rouse is got two cases with us, 19 CR 007905G, in which she's accused of theft by shoplifting, in which a plea offer has been made in exchange for a guilty plea, and the alleged incident date is September 1st, 2019. The second case is 21 CR 003737J, in which she's accused of theft by receiving stolen property, in which a plea offer has been made in exchange for a guilty plea, and the alleged incident date is July 22nd, 2021. Ms. Rouse, you've been advised of your right to remain silent, and your attorney is Ms. Helen. And this is going to be a non-negotiated plea. So Ms. Rouse, the prosecutor is first going to give me their recommendation, and then I'm going to hear your attorney's alternative recommendation. I will consider which one I will select and let you know. Then you can make a decision as to whether you want to proceed with the plea hearing. Do you understand, Ms. Rouse?
Yes, ma'am, I believe so.
Ms. Duncan, what is the recommendation for positions 27 and 28?
For position 27, I was made aware that I think it was the credit for time served that was at issue. We initially had 24 days, so I'm just going to state it with the corrected time. 12 months to serve, 60 days credit for time served, 27 days balance suspended, stay away from the incident location. And it is the same on position 28 in exchange for a guilty plea for both and no further violations of Georgia law.
All right, is the state only accepting a guilty plea on these?
Yes, Your Honor.
And what is the stay away locations, please?
Let's scroll down.
One's Walmart, one's a fire department. I believe.
Yes. 844 Cleveland Avenue. And then the other is, yeah, that's the only one for the stairway. That's Walmart.
They're both Walmarts?
No, the second one is a theft by receiving stolen property. And that was property belonging to the Atlanta Fire Department.
Okay. All right, Ms. Helen?
Yes, Judge, this is a non-negotiated plea. I just want to make sure that we have the credit for time served accurate. For the theft by receiving, she initially did 3 days, July 22nd of 2021 to the 24th. And then the theft by shoplifting, she did an additional 4 days, September 9th, September 3rd through the 6th. Essentially, Judge, she's really close to that 30-day credit for time served. So what I'm asking, Judge, is for this to be considered time served. Because again, 27 days on the theft by shoplifting, and I believe 28 days on the theft by receiving. She doesn't have any issues with the stay away at all, Judge. So that's why we're considering or asking this court to consider this time served. We will ask if she hasn't used her NOLO in the last 5 years, would this court allow her to use that for these two cases?
Ms. Helen, would the defense be amenable to, 1 second, let me pull it up. Get it. 12 months to serve, 54 days, credit for time served, 28 days balance suspended for both of the charges. And as far as her NOLO goes, let me make sure.
What is that?
There is a NOLO already on file, I believe.
I'm sorry, Ms. Harrison, when was the NOLO entered?
I didn't show one, Your Honor. in the GCIC?
There was a theft by shoplifting NOLO out of Gwinnett County in 2012.
Yeah, that's more than 5 years.
Correct.
Okay.
Well, Your Honor, if I could interrupt, first off, the state is offering time served. As far as NOLOs being submitted to the court, one every 5 years is a DDS guideline. That doesn't even pertain to shoplifting cases. I know we haven't really gotten to the defendant's criminal history, but the defendant has a very extensive history when it comes to theft charges and shoplifting, to be more specific. As you're aware, she does have 2 open theft cases before the court this morning.
I do. That's why I was asking.
In
We offer condition upon a guilty.
That's correct. She has 2 open theft cases. She has a long history of shoplifting. The state wants to close these cases out, but we do believe that only a guilty plea will be appropriate based upon her criminal history, irrespective to a NOLA being used in the last 5 years. Thank you.
I understand. And Ms. Helen, that is the state's argument and based on their alleged factual basis. And what is your argument to consider a NOLA plea other than the fact that she's not pled in the last 5 years, which Mr. Walker is correct, is normally a DDS guideline?
Judge, after speaking with Ms. Rouse, I did inform her that if there is a 4th theft by shoplifting, that's a felony. And after speaking to her, she would like to have used her NOLO. But if that's not going to be given to this plea today, I just need to see if Ms. Rouse would still like to move forward.
All right. My biggest concern is that, yes, she does have a history of crimes of moral turpitude, and now she is presently got a robbery charge from February 3rd, 2022, very recent. So I'm going to accept the state's strictly accept the state's recommendation of guilty pleas to these charges. And as you've already told her, if she gets arrested again for theft by shoplifting in the future, it is automatically a felony charge. So, but it would be time served on both charges and to stay away from 844 Cleveland Avenue, the Walmart location. And if she returns to that Walmart, she'll be arrested. So, Ms. Amanda Rouse, would you like to proceed with entering a guilty plea for both these cases?
I will. Yes.
All right. Ms. Helen, do you stipulate to the venue and ID?
Yes, Your Honor.
All right. And Ms. Rouse, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Have you consumed, you may put your hand down. Have you consumed any kind of medication or alcoholic beverages recently?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with the representation you've received?
Very much so.
If you decide to take a guilty plea in both these cases, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel to challenge the state's evidence, to present your own defenses, confront your accuser and examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, I am.
Is anyone forcing you to take a plea today?
No, ma'am.
How do you plead to one count of theft by shoplifting from September 1st, 2019?
Guilty.
How do you plead to theft by receiving stolen property in position 28 from July 22nd, 2021?
Guilty.
Your sentences will run concurrent. It's 12 months to serve 54 days, credit for time served 27 days, balance suspended. Once you've been released from the jail based upon your other case, you shall not return to the Walmart at 844 Cleveland Avenue. They will have you arrested if they identify you and see you there.
Yes, ma'am. Thank you.
Thank you.
Thank you, Judge.
Thank you, Helen.
Thank you, Your Honor.
Ms. Helen.
Position 3 South, who do we, I'm sorry, I'm courtroom 3, hang on. 3 South, who do we have?
Yeah, position number 1, Mr. Barnwell.
Okay, I'll be with you shortly. Who do we have in courtroom 3?
We have position number 7, Whitney Craig.
repeat the case number? Oh, I got
Position
it.
7.
Got it. Thank you. Whitney Cherise Craig is case number 19 CR 008881Y, in which she's accused of battery, domestic violence, and battery against a female who is pregnant from an October 30th, 2019 incident. Ms. Craig, you've been advised of your right to remain silent, and your attorney is Mr. Zach Findlay. Mr. Findlay, what are we doing in this case? Position 7?
Yes,
Is it
Your Honor.
arraignment?
Yes, Your Honor. This is an arraignment. And also wanted to address bond, Judge.
And do you waive a reading of the accusation?
I do.
Ms. Craig, you've been accused of the 2 offenses I've just identified. These are misdemeanor offenses, and you're presumed to be legally innocent until the case goes to trial and the state manages to carry its burden of proof to overcome your presumption of innocence. Upon your entry of a not guilty plea, the case will be scheduled for trial, and the state has the complete responsibility to prove the charge against you beyond a reasonable doubt. If they succeed, you could be convicted of 1 or more of these offenses and face a sentence of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Your case has been arraigned and it's going to be further notice for trial. Your attorney is going to now seek a modification of the bond. Mr. Findlay?
Yes, Judge. Mrs. Craig's current bond looks to be $7,000 surety bond with $3,500 for each count. Ms. Craig, let's see here. Ms. Craig has had a rough go of it since 2014. She did lose a child, as well as broke her and her fiance separated leading up to her arrest. She had been beginning to work, trying to save money, working at a jewelry store. The bond as is $7,000 surety. Ms. Craig just has no chance at coming even close to making that bond, Judge. And that is why we are asking for a signature bond in this case, but if not inclined, then a surety bond not exceeding $1,500, Judge.
Thank you. Ms. Goodry?
Yes, Your Honor. As defense stated, she does have a $7,000 surety bond, $3,500 for each case. When she was first arrested, for count 1, she was given a $3,500 SOB through pretrial. However, pretrial was released due to her failure to appear on March 5th of 2020. A warrant was issued, and that warrant was outstanding for the time being. The battery against a pregnant female was added, and and upon her arrest, she received a $3,500 surety for the battery against a female pregnant. Your Honor, in this case, officers spoke to her mother, Chandra Estelle. She showed officers a visible bite mark on her lower arm that did not appear to break the skin at the time. Ms. Estelle stated that the defendant bit her, causing the mark. They then spoke to her sister, Micah Bristol, who was holding a paper towel on her head, and stated that the defendant threw a laptop computer at her, hitting her on the side of her head, causing a minor abrasion and visible blood. Ms. Bristol was pregnant at the time that this incident occurred. They spoke to the defendant. She refused to answer questions, but she did say, "I bit her because she attacked me." Your Honor, we're concerned that that the defendant will commit this offense again, and for her intimidation of the witness, as she has an open battery case against her mother, Chandra Estelle, from February 15th of this year. She was given a $4,500 surety bond in that case. And in that case, she struck her mother in the face numerous times with a cell phone, causing her to have a swollen lip. Your Honor, so we're concerned that she will reoffend and that she will intimidate the witnesses, which is her mother and her sister. So we believe that a $7,000 surety bond is appropriate in this manner.
All right. Mr. Findlay, you have the final word.
And nothing further, Judge.
The bond modification is denied based on the recent events that have taken place allegedly involving the same victim, as well as a failure to appear. Ms. Craig has demonstrated a very high likelihood to reoffend and pose a threat to the victims in this particular cases. So a request for bond modification is denied.
And
Ms. Craig, you have a right to remain silent. Anything you want, if you say anything, you could end up incriminating yourself. Yes, ma'am.
So, what actually happened?
I don't want to talk about the
Ma'am,
facts of the
yeah.
case.
Ms. Craig, I would strongly advise you to not talk about the facts of the case, ma'am.
So why am I feel like I'm being, she's saying that she doesn't even, this lady doesn't know me. She's saying that I would do it again. She doesn't even know what happened to even say this.
Yeah.
I have things that I have to do, and that's not what happened. Though it may appear that way, that's not how it happened. I didn't attack her or just bite someone for no reason. It was actually self-defense. So what I've been trying to do, I can't live my life if someone keeps coming to me. It's not fair for me to keep
Ms. Craig,
going to jail. And also, please let me just say this. Also, I never just I had to travel back. I had to travel back to Michigan because I'm not from Georgia. I had to travel back to Michigan at that time, and I wasn't just I couldn't receive any mail because they told me I couldn't go back there. So when I got back to Michigan, to my place to the place I stayed, the police told me I couldn't even go there because I had already moved to Georgia. So I couldn't get any of the mail.
Ms. Craig, did you update the court with your new address in Michigan?
I don't have an address in it. I'm saying the previous from the
Okay,
from
so
the charge.
you've not updated the contact information for you. Number two, if you are asserting a self-defense, that is an affirmative defense which your attorney and you will discuss when you go to trial. And that at this point, at this juncture, I would recommend you don't say anything else, because the more you speak, the more ammunition you're giving to the prosecutor to when they prosecute this case against you. And furthermore, the fact that you have a self-defense doesn't mitigate the fact that an arrest warrant was issued against you. So if you want to keep on talking, all you're going to end up doing is making it so difficult for the public defense to represent you. Understood? And I think their Wi-Fi is frozen. So,
No, we're here.
Yeah.
We're good.
Oh, okay.
No, we're good.
We're good? All right, good. I think she's understood, Mr. Findling. That concludes the case with her. Thank you.
That's all in courtroom 3, Your Honor.
Thank you. 3 South, who do we have? Oh, Mr. Bondswell, that's right. Mr. DeMarco Bondswell is accused in case 22 CR 0009498 with an alleged misdemeanor offense of November 7th, 2020. And Mr. Bondswell, we're going to arraign and reconsider bond. Is that correct, Mr. Finley?
That's correct, Judge. And I was not able to find a bond, so I also wanted to ask what they were.
He's not being held on this charge. He was given a citation. He's only being held on felony charges where he has no bond set.
That's.
Thank you, Ms. Guidry.
Didn't we? Okay. I don't want to. So I'm just going to arraign this case at the present time.
Yes, Judge. Yeah, just arraign.
Okay. And do you waive a reading of the accusation? Mr. Finley?
Sorry, I was on mute. Yes, Judge, we do. I do.
Mr. DeMarco Bondswell is accused of a misdemeanor offense, cruelty to animals, from November 7th, 2020. And Mr. Bondswell, as we've said, you presently have a signature bond on this particular case. There is nothing holding you back with regards to this case. You do have other cases in which bonds have already been set, and you need to resolve the bond in those cases before you can secure a release. But in the meantime, this is the misdemeanor charge brought to you in this particular case, and upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of trial, the state has the complete burden to prove the charge against you beyond a reasonable doubt. If the state succeeds, you could be convicted of this offense and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Guilty.
I'm sorry, repeat that?
Not guilty.
All right. So not guilty plea, the case has been arraigned and further notice for trial. That concludes this case. Thank you.
Next, we have.
All right. I think we are done with our, do you have another case?
I have two more actually.
Okay, we're ready.
Mr. Nelson.
So Nelson is position 23. This is going to be a non-negotiated plea in case 22 CR 0008588H, in which Mr. Nelson is accused of battery, domestic violence from a February 18, 2022 incident. Mr. Nelson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. This is going to be a non-negotiated plea, as far as I know. Is that correct, Ms. Duncan?
Yes, Your Honor.
All right. So, Mr. Nelson, the prosecution is first going to give me a recommendation, and your attorney is going to give me an alternate recommendation. I will let you know which one I will select before you have to decide whether you want to proceed with the plea. Do you understand, sir? All right. Ms. Duncan?
On this charge, the state is recommending 12 months to serve, 45 days, credit for time served, 14 days, balanced probated, family violence intervention program, alcohol, drug evaluation, and treatment if necessary. We have no further violent contact with the victim, but a stay away from the incident location.
And who is the victim, please?
The victim in this case is his mother, Denise Nelson.
And there was no further violent contact, right?
Yes. Well, I'm sorry, Diane Nelson, my apologies. And no further violent contact.
And stay away from?
Her address, which is, I believe it's her address, which is 3086 Lone Oak Avenue Southwest. Lone is spelled Lone, Oak Avenue Southwest.
And even though it's no further violent contact, she doesn't want him to return to her property? Is that?
We have requested to stay away, but just because it's his mother, we put no further violent contact.
I know. I'm just clarifying. So normally when it's no further violent contact, the victim has indicated that they are willing to engage with the defendant. But unless the victim has specifically expressly stated, I will have contact with the defendant, but I don't want him at my house.
Our contact at the time was unsuccessful. I haven't heard anything different. So if Your Honor is inclined, we're willing to accept the no further contact as well until we hear differently.
Ms. Diane is here on the line.
Excellent. Ms. Diane, if you please start your video, and I see a Ms. Diane Heinspike, is that correct? Ms. Diane Nelson, if you'd like to unmute and start your video.
Hello.
There you go.
Yes, hello, Ms. Nelson. My name is Judge Lal. Can you see and hear us?
I can see you.
All right, if you please raise your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Nelson, how do you know
Bring him in the house.
Paul Nelson?
I'm his mother.
Okay, and the state has indicated that you would like to have communication and contact with Paul. Is that correct?
That is correct.
Do you have any objection to him coming to visit you at your home or even staying there?
Yes, he resides here. Yes.
Do you have any objection to him returning to his home?
No, ma'am.
All right. Ms. Duncan, I think I'm satisfied that we can go with no further violent contact and to eliminate the stay away. Okay, so what is the defense ask? Thank you, Ms. Nelson. You may mute your screen, please.
Thank you.
Ms. Helen?
Well, Judge, other than those two aspects, it is a negotiated plea. Mr. Nelson just wanted to make sure he can go home to that address of 3086 Lone Oak, as well as be able to have contact with his mother. So we do stipulate to the factual basis, venue, and ID. And if the recommendation is changed from the stay away to no contact, then we do agree with that.
All right, it will be no further violent contact and the stay away is removed. So this is a negotiated plea then. In that case, Ms. Ellen, do you stipulate to the factual basis, venue and ID?
I do, Judge.
All right. Mr. Nelson, you can go back home, but you cannot have any violent contact with mom. In other words, no physical altercations with her. Well, actually, no physical altercations with any household members. You need to keep the peace, and no verbal altercations with mom. If there are any future altercations and the police get involved, you would be removed from the property. You cannot return home, and most likely your probation will be revoked. So do you want to continue with this plea?
Yes.
All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Have you consumed any alcohol or drugs lately?
No.
Are you able to understand the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes.
If you decide to take this plea, you would have to give up your constitutional rights to go back to court, to have a trial before a judge or a jury, to be able to contest the state's case, have the assistance of counsel to confront your accuser, examine witnesses, present your defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Is anyone forcing you to take a plea today?
No.
How do you plead to one count of battery domestic violence?
Guilty.
Your sentence is 12 months to serve 45 days, credit for time served, 14 days. So he has additional time to serve at the jail?
Yes, Your Honor.
All right. And how much more time does he have to be at the jail?
9 additional days, Your Honor.
All right. So he has 9 more days to serve at the jail. Once he completes the 9 additional days, he will be released and he has to report to probation within 48 hours of being released. Once on probation, you will need to complete a 6-month domestic violence intervention program at your expense, and you shall begin that program within 60 days of being released. You understand, sir?
Yes.
In addition to that, you will complete an alcohol and drug evaluation, and if the evaluator says you need treatment, you must submit yourself to that treatment. At all times while you're on probation, you shall have no further violent contact with Diane Nelson, and you may return to the Lone Oak Drive location. Understood?
Yeah.
No illegal drugs, no weapons, and no firearms. Understood?
Yes, ma'am.
That concludes this case. Thank you.
Thank you, Judge.
Please, Sal, did you have someone else?
Yeah, 37, Mr. Young. Young.
Last but not least, all right. Is this a co-defendant case, Ms. Ellen? With Ms. Rouse, or?
I don't believe so. I don't have any information on a co-defendant for this case.
Oh, no, it's a different date. Okay. Just the same location. Okay. We have Rontavious Young in case 22 CR 000851G, accused of theft by shoplifting from a February 17, 2022 incident. You are Rontavious Young, is that correct?
Yes.
All right. Mr. Young, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. This is going to be a negotiated plea. So, Mr. Young, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Mr. Segura, what is the state's recommendation?
We are recommending 12 months to serve 26 days, credit for time served 13 days, ban is suspended, and a stay away from the Walmart located at 844 Cleveland Avenue, East Point.
And with regard to this plea offer, is the state only accepting a guilty plea?
Yes.
All right, thank you. Ms. Helen?
Yes, Judge, this is a negotiated plea. We do agree to the state's recommendation and we stipulate to the factual basis, venue, and ID.
Mr. Young, have you consumed any alcoholic beverages or drugs recently?
No.
And have you understood the proceedings so far?
Yes.
Are you satisfied with the representation of your attorney?
Yes.
If you decide to take this guilty plea case, if you decide to enter a guilty plea in this case today, you would have to waive your constitutional rights to come back to court, to have a trial in front of a judge or a jury, to have the assistance of counsel to challenge the state's case, present your defenses, confront the accuser, examine witnesses, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah.
Is anyone forcing you to take this plea today?
No.
How do you plead to one count of theft by shoplifting?
Guilty.
Repeat that, please.
Can I read Lolo?
No.
Guilty.
The reason I say no is because that's a condition of the plea offer, that the state will only accept a guilty plea. So are you still wanting to go forward with this plea and enter a plea of guilty?
Yes.
Now, you do understand that if you rack in 3 or more guilty pleas on theft by shoplifting, any future arrest will automatically be a felony charge.
Yes.
All right. I accept your guilty plea, and your sentence is going to be 12 months to serve 26 days, credit for time served 13 days. You'll be released within 24 hours if you have no other holds, and the balance of the sentence is suspended. In other words, you don't have to report to probation, but if you return to the Walmart at Cleveland Avenue, they will arrest you for criminal trespass. You understand?
Yes.
Thank you. That concludes this case.
Thank you, Judge.
Thank you, Judge.
All right. I'm just going to zoom for our competency calendar.
Yeah,
I don't believe we have any inmates who are going to be responding. Is that correct?
I have to go get 2 of them from Green North real quick.
Yeah, sure.
I'll be right back on.
All right. Just to go over some of these cases on the probation calendar, position 1 Barlow is given credit for 18 days, placed back on probation to complete 40 hours of community service per week, and report to probation every week until the term of his probation expires. Position 2 was administratively closed. Let's go over the SAP calendar while we're waiting for the 2 competency inmates to come in. Position 1 is arraigned and further notice for trial. Position 2, Bivens, is arraigned and further notice for trial. Position 3 is released. Braxton George was released and further notice for trial. Terrence Cody, position 4 was a plea. Position 5 was this arraigned?
I have that it's a plea.
Okay,
Position 5
yeah, it was a non-negotiated plea, sorry. Position 5 and 6 was a non-negotiated plea. Position 7 is arraigned, position 8 is arraigned, both further notice for trial. With respect to position 8 is specially reset to SAP on March 10th for a possible plea. Position 9 was a plea. Position 10, favors, is released, further notice for trial. Position 10 and 11 and 12 were pleas. Position 13 was a plea. Oh, sorry, that was an arraignment and further notice for trial. And bond was modified. Position 14 was arraigned and further notice for trial. 15 was arraigned and further notice for trial. 16 was a plea. 17 was arraigned and further notice for trial. Position 18 was released and further notice for trial. 19 was a plea. And Ms. Duncan, if you can send in the null pros for the loitering and prowling for position 19, we appreciate that. Position 20 was a plea. Position 21, maze. Was that a plea? I believe it was.
Yes, ma'am.
Yes, Judge.
Position 22 was a plea. Position 23 was a plea. Position 24, Purcelli, is reset to March 24th at 11 a.m. on the competency calendar. Position 25 was a plea. 26, 27, 28, 29 were pleas. Position 30, I've got a request to reset it to March 10th for a possible plea.
Correct, Judge.
Position 31 is a plea. Position 32 is a plea. 33, 34, 35 were pleas. Position 36, Quentin Wilson was released and further notice for trial. And position 37 was a plea. We will commence with our competency calendar and Mr. Howard and whoever, Mr. Walker.
Yes, Your Honor.
All right, anyone who is not involved in this competency calendar at 11 a.m. are free to go.
Judge, does that include me to be excused?
Yes, yes, please. Thank you.
I'm excused. Thank you.
Yes, you are.
And Your Honor, briefly, I had a note that we had a defendant that was on an ORCA calendar by the name of Desiree Houston, and that she was reset to today because she was supposed to appear in person to sign her plea paperwork.
Someone appeared in a pink shower cap in the courtroom.
I don't.
Deputy, the lady who appeared in court, do you know where she is?
She went up to 150. Let me see.
What's her last name?
Her name is,
Yeah, she's supposed to be here in the courtroom. Where'd she go? No, I meant, what did she say to you? Yeah.
Excuse me, Judge, that was the one that's supposed to sign the paperwork, the young lady that came in,
Oh, okay.
shower cap.
I know, but she's supposed to be here for the plea.
she went. I
So
think
she took a plea, but there was an issue with the paperwork. So I guess you instructed her to return today to sign it in person.
Okay.
That's correct, Your Honor.
Yeah, that's the only note that I have.
All right, so I guess then I'll see the paperwork, and if it's satisfactory, then we'll sign off on that. Are you
Okay, so
satisfied, Mr. Walker?
so she did sign the paperwork before she left?
Hold on.
the litigation manager, Ms. Bolton, had paperwork in her hand. I don't know.
I just want to make sure it was taken care of. That's all.
All right, thank you, Debbie. All right.
Judge, I have Ms. Bolton here in my office. She can explain.
Yes. Good morning. Yeah. Oh, good afternoon, Your Honor. So, yes. So Ms. Houston, she did sign the paperwork. So I'm going to forward it over to Mr. Henderson for his signatures. And then I'll forward the information over to you as soon as possible.
Okay. All right. And when you forward it to Mr. Henderson, can you also CC Mr. Ian Walker?
Okay. Thank you.
Thank you, Your Honor.
Thank you. All right.
Your Honor, I just quickly have one question. Where would you like me to send the no cross?
To April Champion, april.champion@fultoncountyga.gov.
Thank you. Have a good afternoon.
You too. Thank you. We're going to stop the recording and the live stream, Ms. Lewis.
Yes, if y'all ready for me to do so, I can do that at this time.
Thank you.